May it please your lordship.
Lordship, with regards to item number 5 of the daily list, your lordship. Lordship, there was an instruction to file an additional affidavit. We have done so. That was filed on the 13th. However, that is not on the records. Therefore, I am under instruction to kindly pray for the matter to come up day after tomorrow, your lordship.
Day after tomorrow would be a bit tied up. Asana would.
Any day this week then?
What is the position of Doug number 19?
Lordship, that would become clear. What had happened is that the land transitioned into multiple DAGs.
25 to 217.
217. Now we are currently in DAG number 270. So the current position has been clearly explained in the affidavit we have filed, your lordship.
And what about Doug number 19, which they are claiming?
That does not belong to us, your lordship.
That is not yours.
That is not us.
And you were supposed to, their case is totally eviction of Doug number 19.
19.
And you say that you don't have anything.
Anything in DAG number 19.
If you don't have anything in Doug number 19, let them go ahead with that to that extent. If your patta land is not being encumbered with, let the deputy commissioner have its own. Let the deputy commissioner will entangle the deputy commissioner here. Let them make a verification. If you don't have anything under DAG number 19, the whole writ petition can be disposed of.
Lordship, I understand. However, my senior has given me
Your
T. Kashyap, your lordship. I appear on behalf of Mr. K.
Mr. T. Kashyap, learned counsel, appearing on behalf of Mr. R. Dubey, learned counsel for the petitioner, submits that an additional affidavit has been filed in terms of the directions passed by this court, where the order dated, last order was
dated 18 to
2026. Registry to list this matter again on 30/3/2026. Along with this additional affidavit. Interim orders passed earlier. There is an interim order to continue till the next date. Yes.
Lordship, with the consent of other side, Lordship, I beg to mention item number 35. Here, Lordship, we have to file our affidavit. It is going to file by today or tomorrow, Lordship. It's sent for signing, Lordship.
It is that blacklisting
Lord.
thing. What happened to the 2 months thing?
It is going on, Lordship.
Let's continue.
stopgap arrangement is
Stop.
Stopgap arrangement.
Lordship.
That was permitted by.
My lord,
Permitted.
When are you filing it?
By tomorrow, Lordship.
And you will require some time to
my
file.
lord, maybe
How
to
many?
another week's time further, my lord.
Mr. S.S. Roy, learned CGC, appearing for the respondent, submits that an affidavit on behalf of the respondents represented by him would be brought on record by 17/3/2026. Mr. B. Pathak, learned counsel for the petitioner, submits that he be permitted further time till 27/3/2026 to bring on record a rejoinder thereto on behalf of the petitioner. Was prayer accepted, registry to list this matter again on 1/4/2024. Any problem, Mr.
Can it be 2 second, my lord?
Second.
Lordship.
Or if you want on 31st also, we can do it.
Lord, 31st is better. First,
31st.
would be in Itanagar, I remember.
31st.
31st.
Obliged.
Obliged.
May I please, your lordship? Lordship, with the consent of both the parties, I beg to mention item number 12 and 34, your lordship. In item number 12, we receive instruction. We need 10 days time to file our affidavit, your lordship. We have taken consent of the other side.
But this whole
The interim order has to continue.
interim order passed earlier to continue till the next date only.
Obliged.
In item number
12, your lordship.
12,
Yes, your lordship.
that whole thing is blocked.
Block.
Why? You have not come up now. He is not even being permitted to sell the
Exactly, your lordship.
blocks which are there.
Because
Who is
of-
for the petitioner?
Petitioner, Mr.
Have you taken the
We
consent?
have taken the consent, Mr. Gauhati.
Yes, Mr. Chaudhary, something?
Item number 5, in terms of your lordship's order,
Yeah,
we have filed an affidavit, it is not on record.
not on.
Now, my lord, we have placed all materials to show that it has got no link with our DAG number 19.
No, what I was telling you
Yeah.
was that if DAG number 19 is the only bone of dispute,
Yes,
you are not a patta holder.
no,
There is already an order of this court
yes,
that your patta land should not be encumbered in any manner.
many manner.
So if they are in DAG number 19,
My lord, we have given materials in the affidavit
Hmm.
to show that army's DAGs are other than 19.
It's not 19.
Not 19. That's why Lordship will kindly take the matter day after tomorrow.
Day after tomorrow, you will have to keep on waiting. There is a big list already. That's why.
If affidavit is called after sometimes. Or 2 o'clock matter, that matter
That
is
matter
there.
is there.
That will not lie long. I don't think.
I don't know how you all will proceed in that matter.
Let us keep it in the second half, my lord, or maybe
We'll
or-
try it on Thursday.
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 Ah.
Thursday.
Deep level.
Because Wednesday, again, you will keep on waiting. I don't know how far it will go.
Okay.
Hmm. 12. You have taken the consent.
Consent, Mr. R. Sharma.
Mr. R. Gogoi, Learned Standing Counsel, Forest Department, prays that he be granted
10 days
Pardon?
time, my lordship.
10 days time to file an affidavit in the matter. Also, prayer is stated to have been made with the consent of the Learned Counsel for the petition. Accordingly, registry to list this matter again on 30/3/2026.
Item number 34, your lordship. We have taken a consent on the side.
34, what is the problem?
34, we are awaiting instruction, lordship.
That appeal has not been disposed of.
Not yet been disposed, your lordship. So we have to take the instruction, lordship.
Hearing was held.
Hearing was
everything was held. Dispose of the appeal.
That call has not been yet been taken, lordship.
The loss is yours.
Exactly,
You
your
have not
lordship.
been able to go ahead with the second
Exactly, your lordship.
LOI also then. And his rights, which had crystallized by this court's orders, that is also now hanging. When?
After being,
So there is after Bihu.
after being, your lordship.
Same point. After Bihu,
Yes.
you're agreeing to that?
Yes.
Praise for 4 weeks time, further 4 weeks time. Registry to list this matter again on 22/4/2024. The pleadings of the parties be completed by the next date of listing. So interim order
Interim order.
Interim
to
order.
continue. Interim order passed earlier to continue till the next date of listing.
There's an interim order in item number 12 also, your lordship.
12 to interim order, so that will also continue till the next date of listing.
Obliged, lordship.
Obliged, lordship.
May I please, Your Lordship? My lord, I am praying for listing of a admission matter.
This
On
court
my-
is not which matter, which
My-
bench?
My lord, civil bench 2, my lord. Civil bench 2, my lord.
Civil bench 2. This is court is gone. Civil bench 2 is gone. Now it is 4, 5, and 3 before 21.
May it please, your Lordship.
Hmm.
Lordship, in item number 14 and 15, I am appearing for the petitioner, Lordship. Lordship, the outstation arguing counsel has some difficulty today. Lordship, as such, I am praying the matter may be taken up on Friday, Lordship.
This week, next week, impossible.
Lordship, in that case, can it be taken up on Thursday, Lordship?
Thursday, we have already fixed one matter.
Lordship,
There is
otherwise,
no point in keeping it just for the fun of it.
Lordship, otherwise, pleadings are
You
complete.
can have it from 30th onwards any day.
Lordship, 1st of April, Lordship.
A prayer is made on behalf of Mr.
V. Shroff, Lordship.
V. Shroff.
V. Shroff.
V. Shroff. SHA
RAFF.
RAFF. Learned Counsel for the petitioner for an adjournment in the matter on account. Also, prayer accepted. Registry to list this matter again on 1/4/2020.
Lordship, this is interim order, Lordship.
Interim order passed earlier to continue till
I am obliged, Lordship.
May it please, Your Lordship? With the consent of other side, I beg to mention item number 7, Lordship. Lordship, may it be adjourned for the today and we
When?
will list it.
you're for the petitioner.
I am for the petitioner, Lordship.
We had asked for the report. Has the report come?
Committee verification team has been constituted.
As the secretary assessed the value.
No, Lord.
Why?
Team has been constituted.
Team,
Some more
only
cases
team has
required
been
for-
constituted.
I have got the instruction and
We passed this order long back that.
Yes,
team
Lord.
be constituted,
Joint
team
verification
will
is
go,
required.
joint verification, assessment, everything.
whole team has been constituted. Lordship.
Whole team has been only constituted on 12.
Again, Lordship, last
6
page,
March. When did we pass the last
La-
order?
9/2/2020.
last page, Lordship. Now, they requested, Lordship, 3/4 money is required.
Hmm?
3/4 money is required for materializing.
Tell me why this board was not constituted. It
Constituted.
pursuant to the
Next page,
directions
Lordship.
of this court.
I already spoke for instruction and
This is constituted after around a month.
yes,
Why?
Lordship. Whole team has been constituted,
Fine,
including
team constitution
petitioner.
is something different, but we passed this order on 9/2.
Lordship.
And you have constituted the team on 6/3.
It's okay,
What were you
Lordship.
doing for such a long time?
This is Lordship, defense also there, maybe some regarding holding meetings and all. Thereafter join,
Were you wanting something?
Lordship, the arguing counsel is out of station.
Mr. Nair,
Lordship.
a prayer is made on behalf of Mr. P.D. Nair, learned counsel for the petitioner for an adjournment in the matter on account of personal inconvenience. Mr. B.C. Mushahari submits that, B.C. Mushahari, learned standing counsel, BTC submits that in terms of the directions passed by this court, joint verification team was constituted by the Secretary Bodoland Territorial Council on 6/3/2026, and the said team would now carry out the verification as mandated in the matter. Also, on the next date of listing, Mr. Musahari shall apprise this court about the steps taken by the joint verification team as constituted by the order dated 6/3/2026. Registry to list this matter again on 1/4/2020.
no, Lordship, last week of May, Lordship, kindly.
You give me that thing,
This-
what they are doing. This is your
Lord,
director.
this now-
What is your director got to do here? The team is there, the team will do.
Team will be engaged, Lordship.
Team
Will be engaged from
go
today itself.
and do the needful.
They already stated, Lordship, kindly, last week of May, Lordship.
You give me. the
Otherwise,
update.
again, I have to.
You have to give
request-
me the update, what the team is doing.
The entire team
It
is,
just has to go and visit the property, make its assessment. come back.
Lordship, already stated, Lordship, kindly, Lordship, last week
I'm
of May.
giving you time till 1/4.
They stated already,
Nothing doing.
they are
We'll
engaged
see
in
on
Lordship.
1/4. We'll see on-
MCC started from today, Lordship.
We'll see on
That is
1/4.
why I am praying for your
We'll
Lordship.
see on 1/4, mister. You.
One for.
You constitute the body, after a month. Do you want me to
Kindly,
write,
Lordship,
do
I am
you want
humble.
me to ask for an explanation for that?
They are,
You
Oh.
give me the update on 1/4.
Lordship.
Lordship, I beg to mention item number 24 with the consent of the petitioner, Lordship. I'm for the respondent number 2 and 3. We have newly been engaged.
Why have you not handed over the possession of the land till now?
Lordship,
Have you taken possession of the land under the Surface Act?
Lordship, we have newly been engaged in this case. We are awaiting certain instruction,
What,
Lordship.
what instruction? The man is hanged. He is neither here nor there. The money is with you for such a long time.
Lordship, sir-
You're for the bank.
yes, I'm for the
Yes.
bank.
I want his instruction, only simple instruction. Why the land is not handed? I don't want a big instruction.
The Lordship,
Lengthy instruction.
a week time may be given, Lordship.
For that, wait. A week's time is required. Land is with you, possession has been taken. That is why you put it up for sale. Simple. We understand it that manner. That you had a land mortgaged with you. Under 14, you have used the powers of the deputy commissioner, additional deputy commissioner, you have taken possession of the land. Then you put it up for sale. Man gets it. Now, why the land cannot be handed over to him?
Lordship,
Sale certificate granted. Why the land can? That much instruction, why so slow?
we will file our affidavit in opposition,
Uh,
Lordship.
forget affidavit, this case's affidavit is not required. I just want that instruction.
Next week may be listed, Lordship.
On the prayer of Miss,
As they,
huh?
as they.
As they. Item number 24. A learned counsel appearing for the respond number
2 and 3.
2 and 3. The matter be listed again on 27/3/2026. On the next date of listing, Ms. Day shall apprise this court as to why the possession of the land in question has not been handed over to the petitioner after his bid for the same was found to be the most suitable, and a sale certificate,
And he has cleared all the,
a sale certificate
was issued.
and a sale certificate in this connection was issued to him after he had deposited the amount in sale amount in question.
Okay.
Just give me that much. Get it in writing, that's all.
Hello.
May I please, your Lordship?
Lordship, I beg to mention item number 54 of supplementary list, Lordship.
Why?
I have taken consent from the petitioner side, Lordship. I am
Then
from
why are you mentioning?
Lordship,
Don't
just
come. If you have
instru-
taken consent, you don't come.
Lordship, instruction is awaited. Similar
Right.
matter is fixed on Friday. Your Lordship fixed.
Similar matter is not fixed on Friday. There is no matter fixed on Friday.
Why do you want an adjournment here?
Lordship, just we are waiting for the instruction, Lord.
54 file to some.
Monday, na? Similar matter.
Monday,
Monday.
but not before Discord.
Yes, ma'am.
Yes, are you admitting the amount?
Lordship, some instruction is required, Lordship.
That instruction was due from 7/11.
Lordship.
Why the instruction has not come?
We have communicated, Lordship.
Who is not giving you that instruction?
Lordship, we have communicated. Similar matter has been disposed of by this honorable court, but they want to give some written instruction. That's why I am waiting for.
From 7/11, they are not been in a position to give written instructions.
Lordship,
Why?
Lordship, thing is that we have communicated on last week.
What is your name?
MM Zaman, Lordship.
MM?
Zaman, Lordship.
Damal.
Zaman. Lordship.
Daman, learned counsel appearing for the respondents number
3 and 4, Lordship.
3 and 4 submits that
Assam Seat Corporation, Lordship.
the instructions with regard to the claim with regard to the stand of the respondents number 3 and 4. Mr. Zaman submits that learned counsel for the respondent number 3 and 4 prays that he be granted time till 25/3/2026 for placing on record.
Lordship, can it be on 28th?
28th,
Friday. Or Monday, Lordship.
23. 3/2026 to bring on record the stand, bring on record the stand of the respondents as to whether they admit the claim made by the petitioner with regard to the contractual dues receivable by him, in the present writ petition. Registered to list this matter again on 23/3/2026. Can they ensure that? Get me in writing. That's will do.
Maybe your lordship. Supplementary item number 52 and 53, my lord. But I need some more time. My lord. Just now I have received an instruction seeking 4 weeks
Have
time.
you taken the consent?
Well, I am searching them. I'll inform them.
You search them, get them, come here.
Obless. Obless.
Judgment has come?
No, my lord, it is argument is concluded, my lord. Judgment reserved.
Concluded.
Judgment is reserved.
So we'll have to wait for that. Then I'll not keep it parted because I'm not taking a bench to anymore.
My lord,
No, the issue is already under consideration by a coordinate bench.
but the, my lord, lordship, my lord, the judgment that referred to Supreme Court, my lord, I have gone through, my lord. This is, my lord, that case is very much fitted with my case.
I know that
Yes, ma'am.
it is already
Yes,
being heard by a coordinate bench. Why should
Yes.
I keep it now pending? Let that judgment
that's
come.
true, my lord, that's true. But,
Let that judgment come, we'll see.
okay, my lord, but,
The learned counsel for the parties have submitted that the issue as to whether the joint committee as constituted by the respondent authorities for consideration of the cases of the eligible teachers for eligible teachers of venture institutions for provincialization of their services has been validly constituted is presently under examination by a coordinate bench of this court, and the arguments in the said matter has already been concluded and the judgment reserved for and the matter and the judgment has been reserved. So in view of the above
6870.
position,
70.
registered to list this matter again after 2 weeks on a date to be fixed by it. Also, the present matter be not treated as parted and or tied up matter.
My lord,
of this court any further.
My lord, I paid, my lord. This is Lordship has extensively heard this matter, my lord. That is
No,
why,
no,
my lord, only that aspect, my lord.
I should not. Propriety demands that I should not hear the matter. Otherwise,
I am
could
not
have
saying that the judgment should
disposed
be
of it
passed.
on that day itself.
I don't pray, my lord, that judgment should come. Only, my lord, that to extend that should be before Lordship. But otherwise, very difficult to, my lord, if it is something, my lord, again, we have to start from initially. That is the difficulty, my lord. Only that to extend,
See,
my lord.
you have done nothing. I was the one who was arguing the matter. So, Mr. Monto, let us.
No, whatever Lordship will think, I have not any objection, my lord.
Mr. Monto, yesterday night, this was troubling me. What to do?
As soon as judgment is.
What to do? There is nothing to read here in this three files. This is here already.
That is
But
why,
the
my lord.
problem is, I thought, no. Propriety demands that I should wait.
No,
for
that is very, I agree, my lord.
So if I can't keep it parted like this, it doesn't look nice. So if it comes back to me, I'm there. I'll hear them
My lord, my lord.
after 2 weeks.
Obliged.
My lordship, may the case be taken after some time and senior is on lights in court number 1.
Who is your senior?
SK Talukdar, sir.
Lordship, can
Whenever he is available, just tell me. We'll have it in the first half itself.
yes, yes. Can it be taken up at 12, your lordship, if it is?
12, done. Paratam.
Maybe your lordship. Lordship, after some time, lordship.
Wait,
Mr. My seniors in law, sir.
now there is an affidavit that has come on record.
After some time, lordship, after some time. Obliged.
You are appearing for?
For, on behalf of Mr. A. Kundu, lordship. He has asked me. Obliged, lordship.
Who is for the bank? Yes, Yasmin, you are there for the bank. M. Sharma, item number 6. Have you got the affidavit filed by LIC, latest affidavit filed by LIC?
Lordship, no.
That goes against your claim. They say that that assignment letter that you have given is not there in their records.
Okay, lordship. I
There
have.
is no assignment against that policy. Ms. P. Chakraborty is here. If you can get Mr. Sharma, nothing like it. Get him.
Okay.
So if that be so, the policy that is projected by the petitioner is the policy that has to be now given the primacy. Your policy has been held to be. That's the case.
Yeah,
Get.
So after some time. Yes, lordship.
All cases time being is difficult.
No, Lordship, actually, Lordship, the matter was supposed to be done by Mr. J. Roy. Lordship, due to sudden rise in blood pressure, he has to admit to the hospital, Lordship.
On the prayer of prayer is made on behalf of Mr. J. Roy. How is he now?
Lordship, he's in hospital. Actually, his
Pressure again went up.
Lordship.
On the prayer made on behalf of Mr. J. Roy. A prayer is made on behalf of Mr. J. Roy, Learned Senior Counsel, for an adjournment in the matter on the ground that he is in
1 week, Lordship.
disposal. Registry to list this matter again on 26/3/2026. Now, what is your instructions?
Lordship, here it says that when the school was provincialized, from that time the building was held, Lordship. The building was already constructed, the school building was already constructed when the school was provincialized, Your Lordship, in the state land.
Constructed?
Lordship,
Who
the
constructed?
government, Your Lordship.
Well, how? That building that was there, that was taken on lease, on rent.
But here the instruction says, it says like that, Your
There is
Lordship.
the affidavit to that effect.
Yet to file the affidavit, Your Lordship. We have received the instructions on last Friday,
And
Your Lordship.
you in the trial court, in the earlier round of litigation, has not claimed the property. You said you have taken the property on rent. Are you paying? Are they paying you rent?
No, Lordship. Yeah, our pay is there.
This
Can
was
we-
never your property. That school that was there, you took it under deficit in its. But
We-
then
we-
to
we also
commercialize that
granted a
school, now
time, Your
they
Lordship.
claim that school is not operating there, it's operating somewhere.
Yes, Your Lordship, it has been in the instructions also, yes.
Bring that on record. next
Yes, Your
week.
Lordship.
On 26, we are taking up the matter. Or shall we give you some more time? Will you file an affidavit?
Yes, Your Lordship.
2-4. Interim orders? No,
No, Lordship.
No,
2-4.
obliged.
Declare.
In the meanwhile, the respondents in the education department shall bring on record their stand by way of filing an affidavit.
Obliged.
Supply.
Lordship, in these two cases, your Lordship has been listed after a long time. May I pray that your Lordship may fix this matter some other day, your Lordship, for final disposal, your Lordship.
The interim compensation without prejudice has already been given.
Made
Now, who will determine the final compensation?
your Lordship, so far as my case is concerned, they have determined the compensation, the competent.
Then it was withdrawn. That's
Then
the second
withdrawn,
case.
and my case is that they don't have the power to withdraw
Okay.
it since review power is not there.
Okay, now if we allow the second case, the withdrawal of the determination of compensation, if we allow,
Then, your Lordship, my case is, your Lordship, they will have to go to the district judge, your Lordship, seeking, they would challenging that order, your Lordship. Because that is what the scheme of the act.
no. This could take some time,
Lordship,
4 and 5
no, not
months,
your
it took some
Lordship.
time. Now, we interfere
Lordship,
with the second one.
Lordship.
Now, are you satisfied with the amount that has been given to you?
No, your Lordship, in that case, your Lordship,
You will have to
either
go-
party,
No?
either party,
We'll have to go before the reference court.
reference court. Your Lordship.
Yes, Mr. Sokia, what do you say?
Let be heard, madam.
Hear it, but let me have my data in my head before the next
This
day.
compensation was assessed, in fact, only for the purpose of, my lord, because the
Ad hoc, they say it's ad hoc.
it is ad hoc because all the time the, my lord, prayer was made for stay of the, so that the possession of the land does not go to them. So they just of their
Now the
own.
project is done.
Project done.
Now payment has been, this matter went to the Supreme Court also, and from the order of the Supreme Court, 80
No,
lakhs.
Mr. Sokia, what I'm trying to tell you is, if that determination is not proper,
It is not proper, apparently not proper.
not proper, then what is the way out for you? You will have to go before the, you can't withdraw it. Because once he passes the order, he becomes funders official.
It was an ad hoc and it has not been implemented.
But now with
To
the
correct-
orders of this
Well,
court, it
the-
has been implemented.
My lord, review of the, my lord, own
no.
correction is there. my
No,
lord.
correction we understand.
Lordship, my lord.
If it was a correction and a final determination, we would have understood.
Lordship, my lord.
But it's a withdrawal.
It's a withdrawal because it ought not to have been made.
So now the land is taken,
My lord,
there is no
certain-
compensation.
Certain
assessed.
parameters has to be taken into consideration while, my lord, computing the things. That was not done. It is only for the purpose so that. an
This was
amount-
done under that petroleum.
Yes, yes.
Yes, my lord, because.
But there are decisions of this court
It's a.
on the
No,
point.
apparently, my lord, the authority, competent authority, they do not have power of review of its own order.
Hmm.
That is a subtle, but here it is not an order. It is an, my lord, ad hoc assessment made for the purpose
Okay.
of.
We
Lordship.
accept your plea.
Lordship.
We dismiss Mr. Borthaku's writ petitions.
Yes.
Both the writ petitions, we dismiss it. But he is entitled to some amount.
Yes, yes, competent
Now-
authority will assess.
Now this court has already released, directed for release of the ad hoc amount, some 2 crores something.
No, not that. That has assailed in the Supreme Court. Supreme Court says you pay only 80 lakhs. So
That went up to the Supreme.
Supreme Court. The amount is lying with the total 2 crores and odd is lying with the Kala, but only 80 lakhs passed to the Supreme Court. So that has been paid. So amount is with them.
So now there are 3 ways. 3 options. 1, we accept Mr. Borthaku's prayer, review not done. Ad hoc one, we say it's final. And if anybody is aggrieved, they'll take their recourse. Second one, we accept your prayer. That is being an ad hoc one. The withdrawal is proper. He has received 80. Let the Kala Now, assess the,
Exactly,
assess the amount
amount,
and pass the order,
past due,
right?
right?
Or third, we say that this amount, which is there, ad hoc amount, fine. This is an order from the Kala. There is no provision for ad hocism. There cannot be an ad hoc award before a final award. There cannot be a preliminary award. It should be an award. One award is contemplated. So we take it as an award. Either party can go before the next higher forum for disposal. And being public money, Supreme Court having said 80 lakhs, we can say so until the determination is made by the competent body, the money which is there, release to release, rest, let it be there subject to the orders of that judge. These are the three options open to this. As prayed for by the learned counsel for the parties. Mr. S. Bhattakur, learned counsel. Learned counsel for the petition also heard Mr. P.J. Soikia, learned senior counsel, assisted by Ms. N. Nirola, learned counsel, appearing for the respondents number
1 and 2.
1 and 2, and Mr. N. Das, learned government advocate, appearing for the respondent number 3. Who is for 3? 3, you will be 3. No, you 3 and 4 cannot be 1. 4. So, as agreed to by the learned counsel for the parties, registry to list this matter again on when?
In the month of April, my lord, last week, my lord, or
Last week of April.
Or your
Fourth
lordship
week,
can
my
take it on 2nd of April. Your lordship.
No problem. You give me a date.
হোক আপোনাৰ সুবিধা মতে কওক মই সেকেন্ড কৰি দিম
4th week of April. That one take on 20th of April to June.
On 2026.
Can it be on a hearing date, your lordship?
21?
Yes, 21.
21.
Problem.
Deeply applied.
Yes. What is the reason for cancellation, rejection of our NOC? Mr. Das?
My lord, only it says Alexa
Rejected.
for.
That is why you have to tell me why. And why have you not been able to tell this limited thing from
My lord, actually, this case is also listed of.
13/10/2023? This matter is pending. This instruction is not coming. Why?
Yes, my lord, it is last listed on 24, my lord. Today, suddenly, my lord.
After a year.
Can it be taken up?
Why the affidavits was not filed then?
That's also, my lord.
Why?
Can it be taken up for a week, my lord?
On the prayer of Mr. N. Das, learned counsel, learned government advocate, appearing for the. Madam, your name?
P. Sharma on behalf of D. Sharma.
Heard Ms. P. Sharma, learned counsel. B or P?
P.
P. Sharma, learned counsel for the petitioner. Also heard Mr. N. Das, learned counsel, appearing for the respondent
234.
number
234.
2, 3, and 4. There is no representation on behalf of the respondent number 1. Mr. Das submits that he be granted time till 27/3/2026 or 31/3/2026 to file his affidavit in the matter.
Or instruction, my lord.
Affidavit or written instructions. To file his affidavit in the matter and to place on record instructions written in writing from the competent authority. Registry, prayer accepted, registry to list this matter again on 6/4/2026.
Oblige your lordship.
My lord, we are filing the affidavit today, my lord. It is in process. And further, my lord, since these notices were, my lord, the petitioner has prayed that there is no dark numbers mentioned, my lord. May I pray that, my lord, the matter may be disposed of with a direction, my lord, to take these steps afresh, my lord, in accordance with law under the Public Premises Act. That can be, my lord, done.
Mr.
J. Decker.
J. Decca, learned counsel for the petitioner, also heard Mr. H. Gupta, learned CGC appearing for the respondents number 1,
2, 3,
2 and 3. The challenge in the present writ petition is to the notices all dated 13/7. One notice only.
Two notices. Sir.
Two
And it's a-
notices dated 13/7/2023. Notices dated 13/7/2023 and 2/11/2023 issued by the. This is again not by the estate officer. This is not by the estate
No,
officer.
not by the estate officer. my lord.
Then
But we, in fact, we have not initiated that because the proceeding has to be
issued by
initiated
the
under the.
senior section engineer /W/BB/AMG NF Railway Amingaon requiring the petitioner to vacate the plot of land in their possession, which the railways claim to be under unauthorized occupation by the petitioner inasmuch as the land in question belongs to the railways. Also, the learned counsel for the petitioner has submitted that the notices, a perusal of the notices dated 13/7/2023 and 2/11/2023 would reveal that the notices have not been although issued for eviction of the although issued requiring the petitioners to vacate the land under their possession, the said notices have not been issued by invoking the provisions of the Public Premises Eviction of Unauthorized Occupants Act, Act 1971, right? 1971.
1971.
Also, Mr. H. Gupta, learned counsel for the petitioner, submits that the said notices although had stipulated that the petitioners would be evicted from the land under their occupation in the event it is not vacated by them, fairly submits that the notices have not been issued by invoking the provisions of the said Act of 1971. Also, this court further notices that finds that in the said notices dated 13/7/2023 and 2/11/2023, there is no particulars of the land mentioned therein, which is stated to be under unauthorized occupation of the petitioners herein. Also, this court, having found that the said notices dated 13/7/2023 and 2/11/2023 to have not been issued by invoking the provisions of the Act of 1971 and further the same being bereft of any particulars of the land which is alleged to have been unauthorizedly occupied by the petitioners herein, this court is of the considered view that the present writ petition may not be detained any further for adjudication and can be disposed of by interfering with the said notices dated 13/7/2023 and 2/11/2023 with liberty to the railway authorities to take appropriate steps in the matter in accordance with the provisions of the Act of 1971 in the event the plot of land in question is admittedly under unauthorized, plot of land belongs to the railways and is under unauthorized occupation of the petitioner's hearing. So in view of the above, the notices dated 13/7/2023 and 2/11/2023 stand set aside. The railway respondents are at liberty to initiate fresh proceedings in the matter, strictly in accordance with the provisions of the Act of 1971, and by disclosing the detailed particulars of the land belonging to the railways, which is alleged to be under unauthorized occupation of the petitioners. Also, with the above observations and directions, the present petition stands disposed of.
The matter may be passed over for the timing, Your Lordship. My senior is on legs.
The respondent has already took time to file the affidavit in opposition. Last date, that is 29/8/2025.
You argue?
Should my senior is.
Hmm?
Also, my senior will argue he is having some visa difficulties.
But Miss
He does.
He does. Then a counsel for the petition. None appears for the respondents. For the ends of justice,
Interim order may be continued.
for the ends of justice, register to list this matter again on 1/4/2024. In the meanwhile, the respondents to bring on record their stand by way of filing an affidavit. Interim order passed earlier to continue till the next date of.
This matter may be tagged along with 7 WPC.
Let them file their affidavit first. Let them file their affidavit first. Second round of matter.
Lordship.
Possible.
Lordship, in the item number 18, Your Lordship. MSP Bhattacharya is appearing for West Bengal, Your Lordship.
Consoli,
Yes, Lordship.
list this matter before any other bench without me. Item number 18.
Habla, Your Lordship.
Lordship, revenue. Lordship, the revenue, we're supposed to get instruction and file affidavit on the last date.
We are waiting for instruction, madam.
Why? Huh? You are who is the person responsible? Deputy Commissioner.
Yes, madam.
Huh? Who is trying to oust him? Deputy Commissioner.
Yes.
Why? Why? Why?
Yes, madam, I have to.
That time we have granted to you from 22/12/2023.
Yes, madam.
We'll ask your Deputy Commissioner now to be here. 1, 2, 3, 4 dates. 2 o'clock.
And after next
2
thing, madam.
o'clock. 2 o'clock. If you don't get it, I know what to do. Poor man, no order. He is a licensed vendor. He's doing his business.
Stay order is there, madam.
Stay order will be there. Let it be there. We don't want this matter to be continued. What is this action you are taking? Calling a man to your office who is operating the thing with a license and asking him to leave. What is the reason? I want to know that. 2 o'clock. Okay. On the prayer of Mr. You are appearing for?
Deputy Commissioner, madam.
On the prayer of the learned government advocate appearing for the respondent number.
Yes, madam, 2 and 3, madam.
Respondent number 2 and 3. Matter be listed on. 19 तारीख है परी? What is it? 20 तारीख? 20.
Yes.
3/2026. Also, the Learned Council, Government Council appearing for the respondent number 2 and 3 shall on the next date of listing apprise this court as to why the petitioner is sought to be evicted from the premises of the establishment of the
Now,
district court office where he is operating e-stamp. Evict the petitioner who is a e-stamp vendor operating under a subsisting license.
in fact, my lord, this office is also not in here, my lord. Now it is has been shifted to.
Wherever it is there.
I will take it. Sir.
Interim may be continued, Lordship.
Interim order passed earlier to continue till the next date only. Money paid,
Yes,
paid. Full.
full yes, yes, maybe close.
My lord, close. Miss Chaudhary,
Lordships. Tomorrow gonna copy.
this case is passed on an order at page 38.
Yes, your Lordships.
Come to page 39, para 7. Just for your, don't argue.
37.
39, para 7.
39.
39, para 7.
Yes, your Lordships.
Have you got the point? Victim Merazul Haq tied
Yes.
due to Tensira Marak. Have you got it? Mr. Emma from the Learned Council.
The less said, the better. I have tried to also raise this point on several occasions that it is time that we started having a rethought about this particular scheme. Because it is now
Madam-
no longer being, it is not being utilized for victims, it is being misutilized. It is,
I'll Sharing Council. You are for the Assam State Legal Services.
yes, your Respond number 3.
For the Assam State Legal Services Authority. 4 also.
No,
District.
no, 1 and 4, DLSA, I don't appeal.
For one, respond number 3. Miss, bottomly here, Miss M. Burma, learned government advocate, appears for respond number 1 and 4. Mr. H. Alia, learned counsel, appears for the response. Standing counsel, finance, appears for the response. Ms. R.S. Chaudhary, respondent number 3. The petitioner in the present writ petition has raised a grievance with regard to the non-authorization to him of the victim compensation amount of ₹5 lakhs in pursuance to the murder of his daughter, late Tengchira Mara. The petitioner further projects that the determination as mandated in the matter for release of the said amount of compensation was already done by the jurisdictional district legal services authority by an order dated 14/10/2022. Also, today, when the matter was taken up for hearing, the learned counsel for the parties have submitted that the amount of compensation, victim compensation as determined to be receivable by the petitioner hearing has already been authorized to him and authorized to him. Also, Mr. Khandakar, learned counsel for the petitioner, submits that the said amount has also been credited to the account of the petitioner. Also, in view of the above developments, there being no further live issue to be considered in the present writ petition, the present writ petition stands closed. The compliance, the compliance report submitted in the matter by Ms. R.S. Chaudhary.
Along with a
No,
copy of the check.
Yeah,
This is DLSA. This is DLSA order
by
check.
Ms. M. Burma, learned counsel appearing by the respond number 4 through Ms. M. Burma, learned government advocate, along with the check issued in favor of a check drawn in favor of the petitioner for the amount involved is kept on record and marked as X for the purpose of identification.
Obligation.
I'm dead.
Yes,
May I please, your lordship? My lord,
demarcation.
demarcation, my lord.
Yes, Mr. Bhattakur, what do you have to say?
Lordship, since they are claiming demarcation, your lordship, in fact, by through demarcation, they want to take possession of my land, your lordship, which I have also been granted settlement, your lordship. Patta has also been issued in my name, your lordship.
Why don't
And
you
so
do-
far as this is concerned, your lordship, so demarcation is concerned, under the Assam Public Service Act, if demarcation is not done even after their application in time, this is an appealable order, and our High Court has coordinate bench has held that this will not be maintainable. Okay. Your lordship, it's WPC number 501/2025, delivered on 6/2/2025.
WPC 50.
501/2025.
My Lord Justice M. Chaudhary.
M. Chaudhary, your lordship.
61.
6/2/2025.
Yes, Mr. Ahmed, what is your case?
My lord, I have allotted 15 bighas of land for special cultivation. And after that, my lord,
Where is your rejection?
rejection, my lord, at page
109.
109, my lord.
No, this is the demarcation order. No, where is your, we are against which order?
Against, my lord,
Their
before
prayer is
September-
only for
before-
demarcation.
Before that, my lord,
That is already ordered.
Lordship.
Then,
but not done. That is why, my lord, before this honorable court, my lord.
yes,
Lordship may kindly come to page 166, annexure F. This is the vernacular one, last paragraph.
Hmm.
দুয়োপক্ষৰ জোখমা সন্দৰ্ভত অসন্মতি প্ৰকাশ কৰে যদিও
160?
166 annexure F. Has your lordship got it?
আপোনালোকৰ affidavit নেকি?
Para?
Last paragraph, lordship.
Okay.
দুয়োপক্ষৰ জোখমা অসন্মতি প্ৰকাশ কৰে because of that.
Jodio.
দুয়োপক্ষৰ জমিৰ বাহিৰে lordship, it is difficult to find out the actual demarcation from outside. So as because they have objected for the demarcation, though they are praying before your lordship for demarcation.
Yes.
My lord,
Let them cooperate.
will cooperate, my lord.
Let them cooperate. Matter ends there.
No, in the first place, why you prayed for a demarcation and why did you object?
My lord, only our part is going to desire, not demarcate the entire 15 bighas of land, my lord.
And lordship, in
And,
a demarcation, no
and the
opposition
petitioner
can
allowed.
be handed over to him.
That is a settled
part of the
position.
Civil court.
Petitioner allowed to demarcate the 15 bighas of land and not claim for possession without calculating, measuring 15 bighas, my lord.
Okay. You agreed to the demarcation being made.
My lord.
Now, once it is demarcated, there has to be some signposts put somewhere.
My lord.
There has to be some sign of the demarcated land.
But that erecting of post, that cannot be done.
No, post or something should be done.
It can be shown. It can be shown.
What
As
benefit?
because if we erect something or put some permanent marks, it amounts to position.
Position.
It amounts to position. That is the difficulty on our part.
Then what is the way out? That it
There
will be
is
just
civil court.
it will be just a
If the civil
exercise
court
in
directs that
futility.
you demarcate it and hand over the position,
It
in that
is-
case we will erect.
It
No,
is,
if both of them agrees that the demarcation will be in meters and bounds, that should be the demarcation. It's already, there is a civil court order.
Always the
no,
demarcation
the
is
civil
effective
court
when-
order is not for demarcation.
It's for possession, your right of the land.
Lordship. Now your lordship will kindly see, they are saying that they are in possession of 15 bighas. I am saying that I am in possession of 9 bighas, which has been settled with me. I have paid premium.
Out of that 15 bighas.
That
Yes.
he says that my land includes his land. So ultimately, this is a dispute to be decided by the
This is-
competent civil court, your
Okay.
lordship.
Now I get it. Third day, learned counsel for the parties at length, registered to list this matter again on 23/3/2026 for final hearing. For further hearing.
Lords.
I'll pass the orders on.
Lords.
Let me get that facts.
Lords.
Mr. Ahmed, you also make your submissions on.
My lord. Deeply obliged.
Same demarcation.
Demarcation. Hello, here demarcation has been done, nothing has been found against me. But the question remains, my lord, what the authority, the respondent number 5 had to file an application for demarcation, who is not a, my lord, patadar. That is one. And secondly, my
Who is
application,
appearing for respondent number 5?
my application for mutation that has been rejected on the ground that this court case is pending. Therefore, your lordship by order dated 10/12/25.
Their names are not shown, lordship, most probably because of that. Respondent number 5 ইহঁতে হেৰি কৰিছে।
No, respondent number 5
APR
notices
কৰা নাই।
did not appear.
Oh.
Yes, what is the stand of yours with regard to the order dated 10/12/2025?
Lordship may kindly come to
No, come to the order dated 10/12/2025.
10/12. May I?
Yes, you can have
Lordship.
this.
It is off. Huh?
My application for mutation status.
Wrong apply, dispute in schedule land, Ukta Takot, WPC number, Usor Soli ase. How can that be? Wrong apply, dispute in schedule land. We wanted to know what do you mean by that?
Ten 12.
Have you got any instruction after that?
No, Lordship, I have to go, I have to.
Mr. H. Sharma, Learned Counsel for the Additional Senior Government Advocate appearing for the respondents. And again, Mr. P.J. Soikia, Learned Senior Counsel, led by Mr. R.K. Talukdar, Learned Counsel for the. Also heard Mr. H. Sharma, Learned Additional Senior Government appearing for the state respondents. Mr. Sharma submits that he be granted a week's time to
2 weeks, Lordship.
2 weeks' time to apprise this court with regard to the query raised by this court wide. To complete his instructions with regard to the queries raised by this court wide its order dated 10/12/2025. So, prayer accepted, a registry to list this matter again on 6/4.
Lordship.
6/4, Mr. Soikia, 6/4/2026. Also, interim order passed earlier to continue till the next day.
From the report, my lord, that after the demarcation is on record, so there is no dispute. But the rejected, my lord.
You are basically, the demarcation is not an issue. You are basically concerned with the rejection of your application for mutation. Now,
But the respondent number 5 has no business with my lands. She has filed an application that I should not be granted sale permission. That is her application, what it appears for the first time from the report that has been submitted. Now, I have been called for twice, my lord, for a hearing, and thereafter they said they'll go for demarcation.
verification.
So I have come this court. Now, while pendency, my application for mutation that has been rejected, saying that
As far as I have understood, demarcation is a non-issue now.
it is non-issue now.
Non-issue now. Now the question is only why your application for demarcation for mutation has been rejected.
Rejected.
The last line thereof, that pendency of the
Yes,
case
yes.
before of this court is not a ground.
It's not a guy.
We want clarification.
Wrong apply.
Wrong apply, disputed land, schedule. What is that? That much will-
Lordship.
If there is something very
yes.
material, Mr.
Lordship,
P.J.
I'll
Soikia will take his own course of action to rectify that.
Yes. Obliged.
Yes.
Well, matter relates to selection of ALD.
That day we deleted the order. Yet I khali likhiba. Heard Mr. B. Rahman, Learned Counsel for the petitioner. Also heard Ms. K. Fukat, Learned Government Advocate, appearing for the respondents number,
5, Your Lordship.
who is for 1, 2, and 3? H. Narangpi, Learned Standing Council, Secondary Education Department appearing for the School Education Department appearing for the respondent number 1 and 2. Miss 1, 2, and 4. 1, 2, and 4.
Commissioner, sir.
Miss K. Fukan, Learned Council appears for the respondent number 3. Mr.
F.A. Hassan.
F.A. Hassan, Learned Council appears for the respondent number 5.
My lord,
Will finance.
inquiry report may be provided to.
That is here. It is with us. We have seen it.
My lord, on the other hand, liberty may also be given to.
As consented to by the Learned Council for the parties, the present petition is taken up for final consideration and disposal.
Three.
When was the provincialization order granted?
Provisional order, my lord, annexure B page 15.
22.
22, 9.
22/9/22. And you approached the deputy commissioner 22/12/2022. What will the deputy commissioner do here? Why did you not invoke the provisions of the
My lord,
section 19?
my lord, I have also applied the director of secondary education Assam and copy of the same has given to DC as well as my lord secretary.
Well, what will the director do? It is he's already funders official. He has given, government has given. Now the only way out to you was, if there was any dispute, to approach the Learned Educational Tribunal.
Well,
You have not approached.
no.
So you wanted an inquiry to be done. We got it done. Now the inquiry report is in favor of the respondent number 5. That is the end of the.
I will challenge it. Inquiry report may be given to me. If there is any information, I will challenge it. My liberty may be given.
You want to withdraw it? I'll permit you to withdraw it, subject to the limitation to approach the Learned Education Tribunal.
My lord, without instruction of
Without
instruction, well,
instruction, then we will dismiss it. Do whatever you want. You will be left with no other alternative.
inquiry report may be provided otherwise.
Will not.
Inquiry report, not to me.
Okay.
My lord.
You want the inquiry report?
Yes, my lord.
এই 2টা বজাত মই ঘূৰি আহিম নহয় এতিয়া এটো মাতিবা
My lord.
a copy of the at the outset it is to be noted that Ms. K. Fukan, learned government advocate, has praised on record the inquiry report submitted by the Executive Magistrate, Office of the District Commissioner Borpeta, with regard to the complaint raised by the petitioner pertaining to the appointment of the respondent number 5 as a senior assistant in Pagodi Higher Secondary School, Borpeta. A copy thereof was furnished to Mr. B. Rahman, permitting him to make his submissions thereon.
No need to further submission. Only I want a copy.
No, we'll give you a copy and may take your submissions. Second half.
Then I will take it from the court.
Second half. A Porokini, Xerox Kuri. You take it, give it back to me. Keta pay the society. Numbering going good. Second half, after 2:30.
My lord, already disposed of matter.
No, not disposed of. I've just dictated 3 lines or 2 paragraphs. Rest, I will dictate after hearing you at the second half.
As per
Lydia, any objection in giving the report? No. It's so fair. You read, tell me.
I don't know what is in the inquiry.
That is why I'm giving it to you. You read.
I will also take it from
Do whatever you want.
from the honorable court also.
No,
by
no,
certificate copy.
No. Today. Second half. After 2:30.
2:30.
Lordship.
Yes, who is appearing for the respondents?
Covered by the judgment order lordship, you will find at page.
Mala, let me file my affidavit.
Why an affidavit? is
Affidavit is
required?
not required in this case.
You want to file an affidavit?
Yes, my lord.
Why the affidavit was not filed till now?
Yes, my lord, it was in the last order, it was said it will file within 2 weeks.
Hmm.
Same has not been filed, my lord.
Then the order before, again, you
Yes,
were
yes.
granted more than 2 weeks. Before that, you were given 3 weeks.
Can it be?
Before that, you were given while issuing notice also. So, you have not filed.
Not filed.
Okay, you file it, we have no problem. 25,000.
My lord,
25,000.
at least, my lord, sometime, my lord.
Sometime, but I'll give you 1 year time if you give me 50,000. Take your time, but that money will go to the petitioner as compensation.
One last chance, man. Last chance, man.
Sorry. I myself have granted you 3 weeks.
Or my lord,
2
can it be taken up at 2, my lord? My lord, actually, my lord, one more thing happens, my lord, our office file is also missing, my lord.
That is your headache.
That's it.
You
Or my lord, tomorrow.
no, today.
Tomorrow is the first item, my lord.
Today, if it has to go,
Tomorrow is a first
or
item.
on your request, it can go only on payment of cost. Now we are not going to
Then, my lord, at 2.
second round of calling. You go through that decision of this court, coordinate bench,
I can counter that, my lord.
whether that is applicable.
Yes.
It is a tentative conclusion of this court that it is a judgment in rem, not in persona. If it is a judgment in rem, he cannot be treated to be a fence sitter.
My president.
You will argue fence sitter. Fence sitter would come in when a determination is made in persona for a particular set of petitioners. This is with regard to the acquisition of land at Hailakandi. There were two parts. One is Hailakandi, one is some Kacham.
Both cases Hailakandi lords.
Hailakandi, but two
Villages are different.
So here the decision is per se that whole area, and his land is also within that area.
He was not a
Distinguished. We are with you. Distinguished.
Public.
Enhancement of land compensation. Literally, madam. How can we?
One case affidavit filed.
Forget affidavit.
In other
What is your grievance here?
This is my affidavit, my lord. So far as Zirat is concerned, it is already been paid.
Paid.
And as per their affidavit that I have annexed with my affidavit, my lord, as annexer, that they have already taken alternative plot of land, my lord. So
No, we have no case. Our case is, my lord, our case is, while they they have taken our land. They have taken our land. We give consent. We hand over our land.
Mr.
Subject to that,
Ahmed, what is your grievance now?
Now grievance is, my lord, low payment has been made, my lord.
Low payment.
Low
That
payment.
means you
Number
want
one.
enhancement of the amount.
Yeah, but then another aspect of the matter also,
This is acquisition under the
13
provisions of
13 Act.
13 Act.
That
What is the provision under 13 for enhancement?
is under section 64.
64 appeal is to be filed. Some cases we file appeal.
Why don't you file in this also?
One is now what is the development now here? After filing of this case, now they have increased some amount. So I bring on
That we are least border. 64, a procedure has been laid down that if you have aggrieved by the amount given to you, follow that procedure. We will not entertain this.
My lord, let them file affidavit. My lord,
No affidavit is required.
Your lordship can see.
No affidavit is
Instructions with
required.
me, my lord.
Your
I
lordship can
did
see.
instruction.
Huh?
Similar set of instruction in other cases also. Item
lordship will
27
say
to
there is
30.
a
At
case.
26, I have already filed affidavit
Your
stating the
lordship.
stand, my lord.
Land 13 Act.
Have to put one.
Instruction received, but somehow affidavit not.
In 64, they may file appeal. They put a.
They may not, they will have
They
to.
will.
This is not the forum to decide this issue.
Correct, my lord.
Very outside,
But
I have
Huh?
raised it. Very outside, I have raised it.
Now you will also kindly see one aspect of the matter. I am missing my book. There is some provisions that
No, land compensation, right to fair.
right to fair transparency, and there is a schedule, my lord. They should provide 50,000 for demolishing the house.
Whatever they have not provided, they have provided some amount to you. You have accepted it.
Now it is for house below.
Okay, whatever it is, it's in a form of an award now.
Yes.
Right, madam?
Yes.
My lord.
And that award, if you are agreed, then you will have to go before the
Yes,
reference
the
to
district collector, my lord.
who has not accepted the award by written application. No, not this.
64, my lord.
So why the provision under 64 is not to be invoked by you?
Yes. In two cases, my lord. Two cases I file appeal in two cases. And
then which cases? In these
yes.
5 cases?
Yes.
Which are the cases you filed appeal? Item number?
Item number, my lord. It is item number 28. A simple event has been filed.
Appeal has been filed, 28, only 28.
Page 36. 28, and another is.
Another case?
Another is 29.
29. So this two cases we did not consider.
And another is, my lord, Zatali. Happy. 3 cases. Simple, there
is no appeal, simple or
simple.
Simple or complicated, it's not that. That is the procedure.
Then, my lord,
then you
yes.
go ahead with that. Withdraw this. We'll permit you to go ahead with
No, you'll also pass it. I will.
No, we'll not pass. We'll dismiss it. We'll say that this is not maintainable.
We'll also give a direction that.
Why should I?
I'll.
No, that is not to be called for. This court is not a post office.
No, Lord, then in this case, in these 3 cases, we file appeal.
You file appeal.
Now, well,
the
okay,
other 2 cases also you will have to file appeal.
Yes.
And all the 5 cases are not maintainable here.
In 3 cases, my lord. 3 cases, we file appeal.
Withdraw it. You have already filed appeal. Why should you proceed with 2 forums? How can you?
Alternative remedies.
How can you have a proceeding before 2 forums?
Well, something has not been done because it is not on appeal. Because suppose there is a provisions.
Show me how this writ can be entertained. There is an award. You have accepted money under the award. Now, if you want an enhancement.
Under objection, we accept.
Be that as it may. If you want an enhancement, that is your prayer, enhancement. Go before the appropriate forum. They will direct you to the district principal court of civil judge.
No.
It has to be before the district collector. He will refer.
64, district collector, and he will.
Collector, my lord, not collector.
Collector.
District collector.
District collector.
That is what I'm saying.
In fact, my lord,
collector will refer it to the
authority.
In fact, he withdraws the cases here, my lord. That limitation may be condoned, my lord. Otherwise, there is either within 1 month.
Limitation here.
He will be losing the forum. It's better for him to. Lordship may
That
condone
will
the
not
delay.
be considered because of the issue of
His appeal also will go.
So your whole thing will go. You will have to again come. Good for you, but I don't know how good it will be for your petitions.
It's my duty to point out, my lord. That is why.
What some observations, man.
We'll say.
No, we'll file a bill.
That.
And that will be considered.
When was the award passed?
Lordship,
my lord, the last occasions, my lord. That is why I pointed to lordships. First, there's award for house value fixed for house property, not GRAP. Then when we approach this honorable court, after receiving notice, now they provided some amount against GRAP. And there is some enhancement, my lord. Those
No,
are,
no, when was the first award passed?
the lordship can list phrase, item one, item
It's
one.
not mentioned,
item
my
one,
lord,
item
in affidavit.
No, no, no.
Already 6 weeks have gone
My lord.
naturally because
It
this
should be.
matter is pending from 2025.
But amount has been mentioned, what is sanctioned and what he has received, my lord.
Oh.
The concerned landowners has received. But
Now we have received, my lord, that list has been given. We have received, my lord, some
And
increase.
tell me,
My lord.
when did you receive the amount?
Going to take,
You have also not in your affidavit said that, no?
lord,
No, no, after filing the affidavit, they have,
no, initially they did not provide that bank accounts and all these things, my lord,
That
providing the
quantity-
zero. That is why in
no,
affidavit
no,
I could not
they
say
increased,
that.
my lord. It lordship can just.
Maybe, my
just a
lord, that
moment,
is
this-
the subsequent
this
step
list-
development after filing this affidavit. That is I am not aware of officially. He
This-
might have that copies, but
These two pages, my lord, just now they are given me, my lord.
Okay, withdraw it. We will ask them
Those are-
to
it's better. to
consider
see, my
the limitation by also reckoning the pendency of period of
To be
pendency of the present
lord.
proceeding.
It is.
And heard Mr. J. Ahmed, learned counsel for the petition. Also heard Ms. M. Borman, learned government advocate, appearing for the
3, 5, 6 and 8.
appearing for the respondent number 3, 5,
6 and 8.
6 and 8. Ms. Borman at the outset has raised a preliminary objection to the effect that the present writ petitions, the above noted writ petitions would not be maintainable in view of the alternative remedy, efficacious alternative remedy available to the petitioner under the provisions of section 64 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013. Also, Mr. J. Ahmed, learned counsel, in view of the said objection raised by Ms. M. Borman, learned government advocate, submits that the petitioners in WPC number 5554/2025, and they have not filed appeal, 554
Two cases not filed.
and 5613/2025 have not filed any appeal in the matter, any application in the matter, invoking the provisions of section 64 of the said Act of 2013. However, the petitioners in WPC number 5637/2025, 5647/2025, and 5648/2025 have already filed the requisite application before the jurisdictional collector.
But when the amount mentioned at that time, how we file a bill. Later on, amount has been increased. So that is why we will file fresh appeal.
Okay, however,
After filing of this.
the respondent authorities, after filing of the said appeal, had again released to the petitioner certain further amounts. Accordingly, he praised that a fresh appeal in the said matter, in the above noted writ petitions would be mandated to be a fresh application, in the above noted writ applications would also be mandated to be so preferred. So in view of the above, Mr. Ahmed submits that the present appeals be permitted, the present writ petitions be permitted to be withdrawn with liberty to the petitioners to approach the jurisdictional collector by way of filing an application, by way of filing individual applications under section 64 of the Act of 2013, and further praise that this court would be pleased to direct the respondent authorities to consider the same applications on its own merits. So, the prayer of the learned counsel for the petitioner is accepted. The petitioners are at the present above noted writ petition stands dismissed for withdrawal. However, with liberty reserved to the petitioners to file appropriate applications within 15 days from today before the jurisdictional collector invoking the provisions of section 64 of the Act of 2030. In the event of filing of such application within
You will-
15 days from today, the respondent, the collector shall consider the said application on its merits and take
For
appropriate action as provided for under section
Mike.
64 of the said Act.
And condone the delay.
That has already been.
On merits,
No, on merits.
consider the application on merits. It is not yet 1 year. Limitation runs for 1 year. If they don't do it, come back, we are here. File a review, I'll do the needful. After dismiss, huh?
Public.
26, 27, 28, 29. Yes.
In it, your lordship, I made one observations. That point may not be raised by the
Which one?
delay. Delay part may not be raised by the.
We have said on
Lordship
merits.
has
Merits will
already said
issue
fresh
today on
appeal.
merits.
Phrase appeal already, Lordship have already.
Even everything, merits.
Please, Your Lordship. In this matter, we have received instruction, we would like to file an affidavit, my lord.
Yes, why is PRC was not raised to him?
Because, my lord, there is some mismatch and link is not established, my lord, and after.
Where is grandfather?
Yes, grandfather, my lord.
Father,
After
son, father,
grandfather.
grandfather.
Yes.
There is a gap between the grandfather and the father.
Yes.
Right?
Yes. And
Records
there is
of the father is there, Javed and
Abed, my lord.
Abed.
Yes. And after field verification, my lord, it was rejected, my lord, by the.
Field verification.
Yeah, it has also been done. We have to file an affidavit, my lord.
Javed, what is your connecting document?
My lord, Javed,
Solid, no doubt thereafter. Show me one document.
my lord,
There should be no doubt thereafter. Your father is from 1997.
my lord,
Connect your father to your grandfather. Javed,
Javed,
who is the owner of a lot of big properties at that point of time.
my lord, my lord, kindly see the page number 23, my lord.
20. That is what I'm saying. This is Abed, not Javed. And Abed and Javed are two different.
My lord, he is actually Javed, my lord. And affidavit was.
Mr. Counsel, this is not a foreigners tribunal. This is Gauhati High Court, 226. I cannot take evidence. I'll have to go what is there.
My lord.
And that's why I asked you one solid document. That is the end of the matter. I'll give the order.
My lord, kindly see the page number 18, my lord.
18.
And affidavit was sought by the Javed Ali
This
in
is a
1993.
self-declaration. This is a self-declaration.
My lord.
Self-declaration has got no value. A self-declaration. I say that I am the owner of this property. I could I am the owner. I file an affidavit. Will that have any legal standing? It's a self-declaration.
Self-declaration.
Section 3. So what was that section? That self-declaration is the affidavit. What is that provision? In section. Okay, you don't have a direct thing.
My lord, kindly see page number 19, my lord.
Okay, 23, 18, now 19.
19.
Let us.
In 19, 21, actually. A plot of land was buy by the Javed Ali, where the name was Abed Ali.
That is the problem. Okay, now you show me the Jamabandi. Mr. Counsel,
My
so
lord.
if you have the Jamabandi here, Jabed, Abed,
There
then
is
your
also-
father.
There is
then
Javed
you.
Ali, my lord.
Huh?
In the page number 21, a land was allotted against the Javed Ali. There is mentioned Javed Ali, my lord.
Jabed, okay.
Javed Ali.
Now this is a document of Jabed Ali.
Yes, my lord.
Plot of land is there.
My lord.
Now, Jabed Ali is no longer in this world.
My lord.
Gone. After Jabed Ali, who got this property?
He got this property by his son,
That means your father.
my lord.
Where is that? Where is that document to envisage that position? Jabed, then your father's name is?
My father's name is Sadek Ali.
Sadek.
Sadek.
Jabed, Sadek, and you are Ziarul.
I am actually, my lord, Abdul Mannan.
Abdul Mannan. For Ziarul?
My son is Ziarul.
Your son is Ziarul.
My lord.
So Ziarul, Abdul Mannan.
My lord.
Abdul Mannan, Jabed.
My lord.
Right?
My lord.
The connection should come, that land should come from Jabed to Abdul Mannan.
Yes. My lord.
The Abdul Mannan is alive today, so it will remain with him.
Abdul Mannan also died.
Right. Then that land will come to the next line of succession.
My lord.
Next line of succession. So I can't help it with this material. They'll have to ask them to file an affidavit. A neat pass student, a good mark. So I wanted you to give me some documents so that I can pass the order now only. Yeah, so and so learned government advocate submits that the instructions in the matter has been received and an affidavit on behalf of the respondents represented by him would be filed on or before. The young boy is involved, will not delay it further.
Yes.
How long?
10 days, within 10 days.
Give me a date. And say next time you have don't file, it will be cost.
Yes,
so take factor that in also. Mr. Mehdi, it will be dangerous otherwise.
5/23, man.
Huh?
23rd.
5/23rd. 25 TDI.
25.
Register to list this matter again on 30/3/2026. 5 minutes, I'm coming back. Mr. Talda, we are taking up the writ petition. Yes.
My lord, I have 2-3 short points. So Lordship, my lord, will decide on those points alone, my lord. It's an admitted fact, my lord, that after the expiry of, my lord, the agreement between the respondent and the petitioner, it was up to, my lord, from 1st May 24 to 31st March 25. Your lordship will find at page 56, my lord, the agreement starts. And thereafter, my lord, admittedly, the contract was not extended. It's an admitted, my lord.
Last extension was with effect from?
My lord, this was, agreement was on 1st May 24 and up to, my lord, 31st March 25. May. 31st May 25. Sorry, my lord. May quote.
Page 56.
57, your lordship. Clause 3.
Yes, Mr.
Yes.
Now termination was?
My lord, this termination order, your lordship will find at page 64, my lord. It is 2/6/25. Now, Lordship will kindly see, the impugn order does not say that you are removed due to non-extension. Impugn order was passed on, my lord, disciplinary ground. If I read the order, my lord.
Yes, please do so.
Yes. Sri so-and-so, it's a my lord petitioner, subject, relieving from the position of finance manager, Assam Skill University project, here so-and-so. This is with reference to the show cause notice issued to you on 27/5/25. I'll come to that, my lord. And your subsequent reply dated 28/5/25. After careful examination, the management has reviewed the explanation in detail. Unfortunately, after expiry, it is found that you were aware of the documents being forwarded to Asian Development Bank and the due diligence to be taken were not adhered to before submission. Further, even after submission, wherein the documents were marked to you over mail, proactive steps were not taken to ensure whether the documents submitted were as per the ADB norms and guidelines. In view of this, it has been decided to relieve you from the duties as finance manager effective from 5/6/25. You have to hand over the charge to so-and-so, so-and-so. Now, the last part, my lord, with regard to certain
Payments.
salary, etc.
Which they say that you have received the amount, but not the documents.
As per terms and conditions of your employment and applicable HR policies, you provided salary for notice, period of 30 days, commencing from the
So what is
effective.
your submission on this?
Yes, my lord, on this, my lord, my respectful submission is, before that, my lord, can I take your lordship to the show cause?
Yes.
What was the ground? Show cause, your lordship will find at page, my lord, 62.
Hmm.
27/5/25, this is the show cause, my lord. May I read it, my lord? To so-and-so, that's a petitioner, subject. Concern regarding performance in AEFS. AEFS submission.
What is AEFS?
Yes, AEFS, my lord, there is a term. I have, my lord, noted the term.
It's in the notice.
Annual expenditure and financial statement.
Yes, correct, my lord. I have noted the term.
It's there in the second paragraph.
Yes. Annual expenditure and financial statement. It is observed that there has been recurring issues concerning the performance of your responsibilities as financial manager for the Assam Skill University project. In particular, the AEFS should have been thoroughly reviewed, verified and discussed with the technical assistant consultant prior to its final submission.
You say you have not submitted it.
Yes.
Then?
This step was especially important given that previous AEFS submission had received critical feedback, which was later corrected with input from TA consultant. However, your recent failure to initiate the necessary discussion with the TA consultant before submission reflects a serious oversight. This negligence has resulted in an incorrect AEFS being submitted. Question the diligence with which your responsibilities are being handled. Considering the serious lapse outlined above, you are herewith show cause and directed to submit written response within 48 hours for internal review. Why you may not be considered for relieving the ASUP responsibilities. So last line makes it clear that, my lord, if the my lord reply is not satisfactory, then on this ground, my lord, they will relieve me. Now my reply at page 63, my lord, to the Chief Executive Officer, so and so, subject response to show cause notice dated 27/5/25. With due respect, I am submitting my response to the show cause notice under so and so regarding the submission of audited entity financial statement of ASDM for financial year 23/24. At the outset, I would like to respectfully clarify that the AEFS in question was neither shared with me nor with any member of my team prior to submission to ADB. Consequently, we were not in a position to review, verify or share the draft with the TA consultant for his feedback, as would have been the standard process. We had made multiple follow-ups with the ASDM for the preparation and financial of the financial statement, which is referred to here as AEFS. It is pertinent to mention that during the audit process, the auditor of ASDM had raised a query on 6 December 24 concerning a difference in the opinion balance. We responded promptly with a detailed justification and reconciliation on 10 December 24. However, there was no further update or request from the concerned authorities regarding any discrepancy or the status of the AEFS thereafter once it was finalized. It was only upon its final submission to ADB and after due approval by the Governing Council, ASDM, and its circulation on 18th March 25 that we received the copy, which was marked to the DPD, Finance Manager and Accountant of ASUP, along with the accounts of ASU and PM Finance ASDM. My lord, basically, this is my reply. Now, your lordship will again see, if your lordship comes to the impugn order, your lordship will find that this particular aspect has not been considered, that I did not, my lord, submit. It is only after submission I received, my lord, from mail. And therefore, my lord, the impugn order was passed totally on a different ground or a different charge, my lord, which is not part of the show cause. If your lordship again come to the impugn order, your lordship will kindly see what they say. This is with reference to show cause noted so and so. After careful consideration, the management has reviewed your explanation in detail. Unfortunately, after expiry, it is found.
Inquiry.
Hello? Sorry, madam. After inquiry, it is found that you were aware of the documents being forwarded to Asian Development Bank and the due diligence to be taken were not adhered to before submission. Now here, my lord, totally.
Any clarification on this in their IA or in affidavit has been filed here?
Yes, my lord.
In the affidavit, any clarification?
I have stated, my lord, that
No. The clarification by
Assam's-
the
Assam's killing.
nothing, my lord. Because my submission is,
We have clarified.
my lord, my
Mr.
learned
Bora-
friend can take
Yes,
seat,
you
my
can-
lord.
you can sit.
He'll have his turn, my lord. My respectful submission is, my lord, the impugn order is passed on a non-existent fact. And therefore it is irrational, my lord. Irrelevant consideration has been taken into account. And under judicial review, your lordship is aware it's a ground, man. Perversity, irrationality, and procedural irregularity. Under 226.
Passed on basing on a
Non-existent fact. Because this charge was never part of my show cause, man. And I could not, my lord.
There was no charges against you in the show.
No,
It
in
was
fact,
in
there
a
was an
form of
explanation.
explanation.
But they did not say, my lord, that you were not diligent. They said you submitted. It wasn't, my lord, with irregularity. That report was irregular. You submitted that. And after I made it clear, they do not say that your explanation is wrong. They do not say, my lord. They do not dispute that I did not submit. My lord, for this purpose,
Just
my lord. Condition to page one of the.
Yes, Mr. Talman.
Yes. My lord, if I take your lordships to page 71.
71.
This is the affidavit in, my lord, opposition by the respondent.
Mr. Talwar, what do you mean to say with regard to the page 64 impugn order is for the show cause? Show cause is directly on the point that while submitting the documents, you had not carried out due diligence by doing a review, ensuring that it is properly done, but you submitted it, which led to some criticism from the ADB authorities. You replied that this was never brought to my notice. This copy was given to me only after the reports were submitted, after the board of directors or board of governors thing to the ADB authorities. In the impugned order, they have modified that stand projection, said that no, you were aware because the documents were marked to you, but still you did not take proactive steps to see to that it is rectified. One. Second, the documents were marked to you over mail. You have not taken steps or proactively to undo that, whatever mistake is there, which had come to your notice now, which should have come to your notice as an expert. You have not taken. These are the two steps. You say that these two are not the allegations in the show cause. That's what your allegation is.
I have explained also, my lord, that what had happened. So that is why, my lord, I am taking your lordships, my lord, to page 71 regarding this issue. Page 71, they have stated, except actually what had happened. And against that, my lord, I have also filed my reply. I take your lordships, my lord, to page 71, para 14. May I read it, my lord? That with regard to the statements made in para 16 of the writ petition, the contentions made by the petitioner are misleading, and as such, it is categorically denied. And the answering respondent would like to humbly state and submit that all the communications regarding the said financial report has been shared with the petitioner also. Discrepancies regarding AEFS, as reported by ADB in June 25, was made known to the petitioner, and the petitioner was kept in the loop in the submission shared on 5th February 25, and then again 13 March 25. Now your lordship will see, thereafter, considering the error reported in last AEFS as the finance manager, it was his duty to proactively follow up regarding preparation of AEFS at every stage and submission thereof. There is no record of the FM following up or taking steps regarding preparation of AEFS. So this was your lordship's query that my lord, had been shared, etc. If your lordship...
No, I'm only with regard to the projections made in the final order, which is now they have collaborated by para 14. That you were brought to the knowledge of that.
Yes.
But the show cause says you submitted. That's the variance.
Yes. Right.
That is the variance. Show cause you submitted. Impugned order and para 14 says that you were in the knowledge of what was being submitted, but you did not take any steps in the event there was some discrepancies there. That's all.
My lord, I'm reading it out. Now my reply. Your lordship comes to my reply. I have filed. The page কিমান আছিলে? If your lordship comes to my lord, from para 4, my lord, I may be allowed to read. Firstly, my lord, I read para 8 of my affidavit in reply against, my lord, paragraph 14 of their counter affidavit.
Para 8.
8, my lord. What?
Page.
My lord, I'm sorry, my lord,
No,
I,
it's
in my reply, para 8. Paging says corona.
Page 94.
I'm sorry, my lord.
That's okay, mister.
Yes, yes.
No issue on that.
Yes, my lord, I can tell your lordship's page.
94. It might be written as 70 there, but the
Yes.
registry has corrected it to 95.
But I am reading it out, para 8. That as regards the statement made in paragraph 14 of the affidavit in opposition, the deponent, while relying on the statements made in the corresponding paragraph of the writ petition, seriously controverts the statements and averments made therein. The deponent reiterates that pursuant to the transition taking effect from 1/1/25, there was a transition, my lord. I'll come to that order of transition. So responsibilities were shifted, my lord, to other department. 1/1/25 in AEFS in question was submitted to the ADB by the Assam Skill Development Mission, ASDM, to which he had nothing to do, as the petitioner, pursuant to the aforesaid transition, was an employee of the Assam Skill University. The report was submitted by the ASDM, and subsequent to, my lord, the transition, my lord, he is an employee of Assam Skill University. So therefore, my lord, neither he submitted the report nor he had anything to do with that. In such view of the matter, the submission of the AEFS by the ASDM could not have been attributed to the petitioner by the respondents, giving rise to the impugned action. Now, if your lordship comes to, my lord, page 60 of my writ petition, the order of transition your lordship will find.
Page
60, my lord. In pursuance of the CEO, Assam Skill University, come register Assam Skill University proposal number so and so dated 7/1/25. The governor of Assam is pleased to notify transition of the project management unit from the Assam Skill Development Mission, ASDM, to Assam Skill University with effect from 1st January 25. Henceforth, the project management unit shall be operated by Assam Skill University as the designated implementing agency. And thereafter, my lord, from this transition, my lord, which had taken into the from the proposal of 7/1/25, my lord, he was the employee of the Assam Skill University.
But this report that has been now submitted, before the ADB, pertains to the same very unit which was transited to Assam Skill University. It's not that something is kept back in the project management unit or the Assam Skill University and something is transferred to the Assam Skill University per se. Now, project university, 2 words, Assam Skill Project, Assam Skill University Project,
yes,
and Mission and Assam Skill University. This is the same thing. No.
No, my lord,
you were a part of that project management unit as a finance manager. You were there.
Yes.
That the appointment orders in the earlier part of your annexures, there is a project management unit and you are a part of that. Right? It was under the control of the mission earlier. Then it came under the control of the university. But it is this project management unit which is doing, and the financial annual expenditure and financial statement is with regard to this project management unit, not with regard to the mission. Project management unit under the control of the mission transferred to the Assam Skill University, but the issue remains the same. Only your employer had changed.
My lord, what I'm trying to say, my lord, this transition makes it clear that my stand that I did not, my lord, submit
No,
the report.
because the transition, that's what I'm trying to understand from you. Transition, it's just a transfer of the unit from one body to another. So the body, when was this submitted, by the way? When was this report submitted?
I'm coming to that, my lord.
Like that.
63, my lord, my reply is there.
Financial year 23-24.
My lord will see, my lord, 1, 2, 3, 4. Fourth paragraph, my lord, I made it clear that only after, my lord, it was submitted to the ADB and being approved by the governing council, I received it on 18 March. So there was no scope on my
So
part.
what do you say after 18 March?
Yeah.
Because the show cause came on 27/5/2025.
Correct.
Admittedly, there is some discrepancy there. Why, as a project manager, you did not highlight that?
My lord, my submission, respectful submission is here. After the submission, my lord, it was submitted. It was approved, my lord. Yes, submission was already made.
No, submission, approval for submission.
Yeah.
Approval for submission
Yes.
was made by the board. Matter went to the ADB. Let us forget the first part that you had submitted it. Let us,
No, my lord,
let us give it to you.
Yes.
Let us give it to you. Let us deem that you had not made the submission. But after the submission was made, you also admit that a copy thereof had come to you on 18/3/2025. There apparently was a discrepancy. Why this was not projected by you?
No, my lord, lordship will kindly appreciate. My lord, as per the show cause, the explanation which was sought for, I replied. Now, in the show cause, my lord, this explanation was not there. It was not there, my lord. Explanation was that you submitted a defective report. So how could I have, my lord, explained that to the authorities? And on my explanation, the impugn order has already been passed, my lord. So this particular subsequent stage in my respectful submission, my lord, it does not arise at all. Because admittedly, my lord, the impugned order, my lord, is passed in terms of the show cause, which is, my lord, the causes, my lord, in the notice dated 28/5/25. So they have to deal with, my lord, this particular grounds. Suddenly they come to different grounds and they relieve me.
Okay.
My lord will kindly see HR policy is there, page 42. My lord, this is the HR policy. I have annexed, my lord, the relevant extracts.
Okay,
For-
we'll go very relevant extra.
Yes.
Page
My lord,
42.
it starts from page 42. The procedure is prescribed, my lord. Disciplinary procedure, page 45. It's part of the agreement. So therefore, this does not come out of the blue, my lord. How
Want
they
to
have,
rely upon that recent decision of the division bench. Wherein a procedure is prescribed, you'll have to comply with that. Are you trying to rely on the judgment of my lord Justice Suman Shyam, which had gone up on appeal? Upheld.
well, that I am not aware of the judgment. But my lord, my submission is, you have laid down this procedure. So in terms of lordship is aware that if I rely on International Airport Authority, that you are required to scrupulously follow.
What is that project disciplinary procedure?
Yes, my lord, here your lordship will see page 45. It starts from 45. Firstly, my lord, they said that a certain counseling has to be done. Secondly, my lord, warnings. And thereafter, my lord, examples of minor misconduct, which comes under warning. they have to also give verbal warning. Then, my lord, the example of gross misconduct on the basis of which, my lord, one can be removed from service, and my lord, so-called misconduct does not fall under this category. Example of gross misconduct at page 46, theft including unauthorized possession of ASU project, breaches of confidentiality, prejudice to the interest of the ASU project. I have not.
That is why the projection on their part is, say we have not done anything punitive here against him. What we have done is, in terms of the appointment order, we find that his service is not up to the satisfactory level, so we have asked him to do. There is no stigma attached here. That is why they have not followed the procedure. Mr. Talukdar, there is another beauty here. It's just written warnings. There is no determination as required under the 64 rules that a show cause notice will be issued. You will supply. Then there will be an inquiry where the allegations will have to be proved against you. Here, warning, then final warning, and then tata bye-bye. That much only. Here, please don't mind that I've already made up my.
No.
What I'm trying to
just
just get
deliberating my-
elicit an answer from you.
Appropriate order.
Now the show cause notice, if you see, come back to the show cause notice. The second paragraph, last line. Okay. Then,
my lord, what I am submitting all is, I was appointed pursuant to a regular selection. This is a regular selection, man. Though, albeit on contextual basis.
so you mean to say that till the project is on, you will have to be kept there?
Correct, my lord. That is one of my argument in Abdul Qadir's case. Your lordship is aware that it is coterminous with the scheme, my lords. The lordship is aware of the Abdul Qadir's case, my lord.
I will take your judgments together.
Yes, correct. On your lordship's query, your lordship has pointed out to show cause. What all I was trying to say, that having been appointed pursuant to a regular selection, my lord, my ouster should be, my lord, fair. But, my lord, I feel, my lord, that here is a case, my lord, it is not based on fairness. You are seeking to remove me.
Okay, fairness is one aspect, but you have argued that what you projected against me is not the final conclusion you arrived at.
That is, my lord, the unfairness.
Fine. Anything more, Mr.
I have, my lord. So, my lord, what my lord Abdul Qadir says, that a person, my lord, obviously cannot be retained for all the times to come. My lord, the employer is entitled to remove him on disciplinary ground, man. Abdul Qadir says, man. And the contractual appointee is also not entitled to regularization, man. I am not asking anything all of this, man. But if you want to remove me, you remove as per your HR policy and on the basis of fairness, man. It is part of agreement. This is absolutely, my lord, an order which is.
This HR policy is of the Assam Skill University project.
Yes.
But this project is no longer there. According to your submission, transition took place.
No, project is there. My lord, it is
If
being
the
funded.
project is there, the transition is of no consequence.
No, my lord, what I was trying to say.
Because this will be contradictory.
No, what I was trying to say, transition makes it absolutely clear that the stand which I had taken, and from the impugn order also it reflects, my lord, they do not say that you did not submit. They, my lord, subsequently they resile from their earlier ground. They do not say, my lord.
That
you
we have
not-
understood.
Yes.
That
So
we
how
have-
come you can, my lord?
You can even argue that what was, just say in a departmental procedure, what was proved against you was a charge which you were never charged.
Yeah. So therefore, when you have sought for the explanation from me,
But this argument that because of the transition, the earlier body which did not have any
that's
jurisdiction.
on the basis of the materials your lordship will decide, man. But the impugn order, my lord, my respectful submission is, it is based on totally non-existent fact.
Fine, got it.
Yes.
Then
My lord, my humble submission is, as my lord, it has come out from the respondents. Now they have, my lord, initiated a recruitment process to appoint another on contractual basis. Now, your lordship is aware, PRA Singh, approved by Uma Devi, Constitution Bench. My lord,
but Mr. That argument, my thought. If we hold that your non-extension of contract, your consequential release is bad. It should not have been done. So we'll have to interfere with the order, impugned order in the present. Then the issue before this court would be how to proceed further. There are two ways. I can use my power under 226 and say that because you have done it in an unfair manner, put him back like it was done to you last time by this court. Put him back and then extend his services and do whatever you want to do in a manner known to law. Second issue now that is troubling me is on the date you instituted the present proceedings, there was no contract existing between you and the employer, whoever it is. Now, in such circumstances, GRIDCO is there. Decision of Supreme Court in GRIDCO and Uttar Pradesh Power Corporation, Suresh Kumar. These two decisions say 226 power hands off. You cannot go in because you cannot now get a contract executed in the matter in guise of exercise of your power of review. The Supreme Court decisions say the only way out to you is go before the civil court under the Specific Performance Act and get your damages, claims, whatever it is. How do you answer to this?
my lord, here my respectful submission is, there are other judgments also of this honorable court. Yes.
I'm talking about two decisions of
the Supreme Court. Yes. My lord, my submission is, I have to go through to that judgments, but the facts, my lord, perhaps will get distinguished on this ground.
No, the facts therein also was the, in GRIDCO, it was contractual expiry of period of contract. Suresh Kumar, there was a period left, but termination occasioned, right? Supreme Court said, okay, continue it till the date when the original contract is to hold the field, and then gone. But in both cases, the Supreme Court did not permit extension of the contract.
Correct, my lord. Here,
2011-15 SSC 16, GRIDCO, Sadanand Dolat.
15 SCC.
Your lordship, if I
60.
may produce.
60.
And the second one is 2011-15 SSC 180.
180. Here, my lord, I'm relying on Abdul Qadir. My specific, my lord, submission is
Abdul Qadir.
Yes.
Your lordship, I'm placing GRIDCO and other two judgments which fell from your lordship in a very similar situation. One is Judy Borman, and the other one very recently, your lordship, which fell from your lordship was Gias Ali.
Okay.
My lord, if your lordship comes to page 17, this is from this honorable court. there was a scheme, my lord, of the central government
Hmm.
for prevention of the infiltration. And
Oh,
Yes, yes.
that's
yes,
a different
lordship-
issue.
lordship is aware.
altogether.
But this is under scheme, my lord. If your lordship permits me to read 17
Hmm.
for my satisfaction, my lord.
Para?
Para 17, my lord. When the ad hoc appointment is under a scheme and is in accordance with the selection process prescribed by the scheme, there is no reason why those appointments under the scheme should not be continued as long as the scheme continues. Ad hoc appointment under scheme are normally coterminous with the scheme, subject of course to earlier termination either on medical or disciplinary ground or for unsatisfactory service or on attainment of normal age of retirement. Irrespective of the length of their ad hoc service of the scheme, they will not be entitled to regularization nor to the scrutiny of tenure and service benefits available to the regular employees. In this backdrop, particularly in view of continuing scheme, the ex-serviceman employed after undergoing the selection process need not be subjected to the agony, anxiety, humiliation, and vicissitudes of annual termination and re-engagement merely because their appointment is termed as ad hoc appointments. My lord, a notification was issued, annual termination and re-engagement. And Supreme Court says it opened, my lord, the door of arbitrariness. So since they were appointed under the scheme, if you dismiss them, remove them under on disciplinary grounds, normally their appointments will be coterminous with the scheme.
And this is not a case of contractual appointment per se.
Correct, my lord. This was contractual, not contractual appointment per se,
Any other
but they were
decision?
appointed under
Any other decision?
other decision is, my lord, PRA Singh, that no, my lord, Umar Devi has, my lord, affirmed that the contractual appointee.
One set of contractual employee, one set of temporary appointees should not be replaced by another set. That's an accepted principle. Yes.
This is my respectful submission.
Yes, Mr.
Lordship, first and
Why
foremost,
was he terminated in the process?
Lordship, first and foremost, as my learned senior has actually placed that he tried to project it in that way that the petitioner was never a part of the ASDM project mission. Now, if I may
That is a
Just for your-
supplementary issue taken. by
just
Mr.
for my
Okay.
satisfaction, your lordship,
Okay, for your
And-
satisfaction.
page number 34.
To get you into the flow, okay.
Yes. So page number 34 is the earlier contract when he was appointed. When he was first appointed in the project management unit under the
It's
Asian
the
Development
project management unit that is being transferred from.
Transfer. Since that is the projection that is being actually tried by my petitioner.
Hmm.
Here, he was engaged as an employee in the project management unit under the ADB Finance Assam Skill University project. So he was engaged under the Assam Skill University
That
project.
was being issued, was being operated or executed by a mission society.
Now that got transition under
To the Assam
Skill University.
Skill University.
And that is reflected in the
The
agreement
transition.
itself. In the agreement itself, at page number 57, there he was thereafter engaged in a new contract as a finance manager in the project management unit under the ADB Finance
Where do you
Assam
read it?
Skill University, page 57.
57. Okay.
So this PMU as such, it was always there. It is not that he was never a part, he was not part of the earlier
Okay,
mission.
fine. Forget
That
that.
is there.
Forget that.
Then I may
We
take
can
your lordship.
disagree with that.
Yes,
Because if we accept Mr. Talukdar's argument on the first phase of his argument, then that will be contradicted by the second phase with regard to the disciplinary proceeding.
Yes.
So we are not going to cause prejudice to him.
Yes.
We will neither allow the repetition on that point nor dismiss the repetition.
Yes.
Now let us come to the core question.
Now
Why was he terminated?
he was not terminated, as we have stated.
Terminated is a word used for convenience.
Now the fact is, as your lordship pointed out the Greatco case, as your lordship pointed
You
out.
come to your facts.
Yes, I am coming to my facts, your
You
lordship.
come to page.
It's a contract
No, you come to page 83.
83.
Because that is the basis of the action.
Yes, your lordship.
Hmm?
That is, this performance sheet is with regard to the earlier,
Or not
not this.
Okay.
This was when he was terminated earlier.
Earlier.
Then
Okay.
also his performance was taken into consideration.
Now come to the
We have-
issue now. Why was his contract not? Normally, his contract should have been extended.
Normally, subject.
Why was it not?
Now, your lordship, if I may take your lordship to the contract agreement at page 57. The page 57 itself, clause 3 of the contract agreement, it says the term of the engagement shall be purely contractual and shall automatically terminate after 31st May. Now, even if we did not say, for example, if suppose for sort of sake of argument, we did not give this 27 May notice, so-called notice, or for that matter, we did not actually give the impugn order, issue the impugn order.
And it is an end.
End itself. That is my submission.
Whether stigmatic, not stigmatic, that is.
Doesn't matter.
But now, Mr. Bora, you were benevolent enough to issue a show cause notice.
Show cause notice. And
Admittedly, the show cause notice is not alleging against him a misconduct. It is with regard to the performance of his
performance.
That much we give you. But what is that duty you are asked, duty you are highlighting, which he failed to perform?
That is what in his writ petition, the petitioner's writ petition at para number 16, what he has stated, and our reply at para number 60, page number 72 of our affidavit in opposition. Since my learned senior has already read out para number 14, I won't take your lordship to para number 14. I'll start from para number 16
of your
affidavit in opposition, page 72. With regards to his performance. That with regard to statements made in paragraphs 18 and 19 of the writ petition. Para 16.
Okay.
That with regard to the statements made in para 18 and 19 of the writ petition, the contentions made by the petitioners are categorically denied and would reiterate the submissions made by the answering respondents at para 9 of the affidavit of opposition for the sake of brevity and avoiding repetition tautology. However, the petitioner's performance thoroughly appraised by the ASUP authority. After receiving the reply from the petitioner and thoroughly going through the same, the ASUP authority came to a conclusion that the petitioner was delinquent in his duty and it is not fit for his position as finance manager, and hence he was terminated full and final settlement, which he never denied. The appraisal of
the reason for non-extension of the contract is his unsatisfactory performance. So that much you will have to accept.
Yes.
That it is not that you did not want to extend.
Yes.
We don't want this post.
Yes.
It was because he was not found to be working in the expected level.
Yes, we have stated in the affidavit also.
Then go ahead.
The appraisal of the petitioner is enclosed in the confidential report cell of HR cell, ASUP, Annexure D, which your lordship took page number 82. Your lordship took me to page number 82. Then the petitioner is that
This is
appraisal earlier that appraisal takes place. That appraisal 83.
This appraisal
yes
of 24.
Yes.
You had extended the contract again.
Yes. We have extended the contract and
till May of
till this is dated, your lordship. If your lordship may kindly note the date, 18/4/24 need not renew the contract. Then we did not actually wanted to renew the contract back then.
Because of the orders of
back, because of the orders of this court, we had to again take him back. And that's why we entered into page 57.
Page 72 and 73 brings on record unsatisfactory service.
Yes.
Right?
Yes.
Now, how was this unsatisfactory service put to him? This was put to him by you. That is page 62.
Page 62, 27.
62. The allegation is, with regard to unsatisfactory service, that while you submitted that report to ADB, you did not verify, review to see that it is in accordance with
the
norms
ADB
of the-
guidelines.
Right? That is the allegation.
That is the allegation.
He comes up and says that this was never submitted by me. It was only after submission.
After submission.
Copy had come to me. Right?
Yes.
Now you come to the main order.
Now,
Impugn order.
now, your lordship, to the impugn order, your lordship, page 64. This is with reference to show cause issued to you on 27/5 and your subsequent reply. After careful consideration, the management has reviewed the explanation in detail. Unfortunately, after inquiry, it is found that you were aware of the documents being forwarded to ADB. He was aware, and the due diligence to be taken were not adhered to before submission.
Where do you get that?
Your Lordship, as we have stated in an affidavit only, that he was aware way back in the month of February and March itself.
Wait.
At para number 14, page number 72. It starts at page number 71, para number 14. The contentions made by, so next page, Your Lordship. And submit, I'll start from and submit that all the communications regarding the said financial report has been shared with the petitioner also. Discrepancies regarding AEFS as reported by ADB in June 2025 was made known to the petitioner, and the petitioner was kept in a loop in the submission shared on 5th February 2025 and then again on 13th March 2025. We have also annexed that email also, Your Lordship. Now, Now, if I may take Your Lordship to the prayer portion, Your Lordship, what the petitioner wants, Your Lordship. Now, as I've actually placed, as Your Lordship, I actually raised the issue of Britco, Your Lordship. Now, my respectful submission would be, Lordship, the judicial review of this administrative action would come into the scenario only and only if there is some kind of illegality or perversity or unreasonableness or unfairness or irrationality, as held by Gritco case. In the pleaded case of the writ petition, Your Lordship, nowhere it is pleaded in this writ petition at all that there is irrationality or illegality or for the matter. Here, let me take Your Lordship to the prayer portion, Your Lordship, because that is very important. What he wants this honorable court to do is step into the shoes of the executive and extend his particular contract, which is there. The prayer portion is there itself at prayer number 4. Prayer number 4 says, a writ in the nature of mandamus should not be issued, directing the respondents to continue the service of the petitioner as finance manager of Assam Skill University project, and a writ in the nature of mandamus should not be issued, directing the respondents to renew the agreement with the petitioner. Now, this, Your Lordship, as has been held in Gritco as well as Your Lordship in jury Sharma case, as well as jury Burman case, as well as the Gyas Ali judgment, as well as Ajay Kumar Holoy judgment. All these
Justice Wipes.
Yes, Your Lordship. That is where it all emanated, Your Lordship. Once the contract is over, now that particular, the scope of judicial review is very limited, Your Lordship.
Okay. But
I place those judgments, Your Lordship.
But Mr. S.K. Palukka, Learned Counsel, also heard Mr. E. Vora, Learned Counsel appearing for respond number
2 and 3.
With petition. The respondents number 2 and 3 had instituted a interlocutory application being IAC number 3330-2025. And had instituted the above noted interlocutory application, praying for vacation of the directions passed by this court-wide order dated 25/6/2025 in the present petition, as well as to permit them to take the recruitment process initiated in pursuance to issuance of the advertisement dated 5/6/20 to the post of finance manager in the Assam Skill University project to its logical conclusion. Also, as agreed to by the Learned Counsel for the parties, this court has taken up the writ petition for final consideration. Also, the Learned Counsel for the parties have been heard at length. Also, hearing concluded, registry to list this matter again on a delivery of order on 24/3/2026 for delivery of orders as the first item.
Till then, the interim shall continue.
Interim order passed earlier to continue till the next date of list.
My lord, I have, for your lordship's convenience, prepared a written argument that may be accepted. My lord.
Always helpful.
I am deeply obliged.
We will have a division bench. And in possibility after that, I'll come and take up the other.
Please, Your Lordship. I'm sorry, my lord. As per instruction of my client, my lord, I want to withdraw with liberty.
Withdraw.
With liberty to approach tribunal.
What did you see? Copy so and so. লিখেছিল আমি কপি এটা এনেকে Mr. B. Roman, Learned Counsel, appearing for the petitioner on perusal of the said report, comma, and as per instruction of the petitioner, has submitted that he would like to withdraw, he would pray for withdrawal of the present he prays for withdrawing the present writ petition. He prays that the petitioner desires not to press the writ petition any further and accordingly prays that he be permitted to withdraw the present writ petition. Submits that petition. Also, the said prayer is not objected to by the learned counsels for the respondents. Also, accordingly, the present writ petition, no liberty will be.
My lord, approach before.
The present writ petition stands dismissed on withdrawal. I'll pass the orders on merit. There is no problem for me. You want to withdraw, you withdraw. Otherwise, we are passing it on merit. It's always open to you to go before the
Tribunal.
But not here.
My lord, no. In my submission, that may be recorded, my lord. My submission, in my submission.
Praise that it desires not to press the present petition. Accordingly, Mr. B. Roman prays that he be permitted to withdraw the present party to the petition to approach the jurisdictional educational trial. Also, accordingly, the present writ petition stands dismissed on withdrawal with liberty to the educational tribunal, if so permissible in law. To institute proceedings before the educational tribunal, if so permissible in law.
Published.
Lordship, in this case, on earlier occasion, we took time for filing affidavit. We have received the instruction, but the
What is
file
the
was
instruction?
it was reassessment.
Now, this order is covered by, this is Hailakandi bypass. There is already a order passed with regard to that bypass by this coordinate bench of this court. Have you gone up on appeal against that?
I have not seen. I have not seen.
That's there in the writ petition itself.
But because the file was misplaced by our officer, now it has been reconstructed.
On the prayer of Mr. B.J. Talukdar, learned
week's
for
time.
petitioner, registry to list this matter again on 2026. On that day, we will see. Mr. Talukdar shall, for the purpose of enabling Mr. Talukdar to examine as to whether the Directions, order dated 28/3/2023, passed by a coordinate bench of this court in WPC number
1452 of 2020.
1452 of 2021 would also cover the issue arising in the present petition. We'll pass the orders on Friday, don't worry. Address, you want to address now? I'm ready to hear it. Mr. Kundu, your affidavit is that the contentions of the petitioner is correct.
Yes, Lordship.
Right?
Right, Lordship.
The contentions of the bank has not been found to be correct by.
Correct, Lordship.
Okay, what more can we do? Liberty is yours. Have you seen the affidavit?
Yes, your lordship, just before I have get this.
What
affidavit,
is
earlier it
your
was not
stand on
served.
that?
So if your lordship will give us a short date so that if required by tomorrow, the instructions from the bank that.
But see, this is a very affirmative statements made here
Yes.
from records.
Yes, it's direct.
Direct statements. There is no ifs
there is
and
no
buts
if
here.
that buts.
Yes, from the policy also, Lordship, I can distinguish, Lordship. Being a fact, because if Lordship takes the Canada Bank's policy, Lordship, the here last column, Lordships, it was written as a 20.
Yes, I think I had given.
It is there.
Where?
I'm.
There's an- I think this was produced by you people.
Yes,
Both of you have produced and I had asked, given it to Mr. Kundu.
Yes,
Yes.
Lordship.
What is there?
In the last premium, as per this his premium, Lordship, the given due date of last premium, Lordship, it was written as a 28/4/2011. It should have been 16 because the premium is of for 6 years. So that is the concrete evidence that this is a fake been made.
So Mr. Sharma has been taken for a ride.
Or else your lordship, we may be relegate to for our remedies available civil court.
I want that from you because now, because of your disclaim, the lady is suffering. The person is suffering. So she'll have to be compensated for
to
her.
file an FIR, your lordship. There is no other way out.
But you projected a wrong document.
No, your lordship, whatever document in our record, we have projected
See,
only on that.
Mr. Sharma, please don't make those submissions. Once that document comes to you, it is your duty to take it to the LIC office, wherever from where it is issued, and get it assigned. It's your duty. You did not do it. Show me that you have done it.
Yes, sir.
Who got it done for you?
One is the assignment has been approved and another is the certificate.
This is denied.
Where is that assignment mark in the policy?
Yes.
There, show me. So this was sent how? To the LIC authorities, how did you send this?
Might be by letter, your lordship. I have to go further on that, your lordship. This has been issued from the LIC office.
Right corner, Lordship, due date of last premium.
No, that is the policy.
In
My
the policy.
assignment was already been stamped by the officers, your lordship. That it is a fake or a genuine, we cannot say.
My grievance is against LIC. Now LIC is saying there is no assignment.
One order of this court opened up the.
My lord, that's true.
Have some patience. Let Mr. Sharma also have his share of instructions. Mr. Kundu, learned, Kundu, learned, counsel appearing for the respondent's number. Your respondent number?
1 to 4, Lordship.
1,
1, 2, 3, 4.
1, 2, 3, and 4. shall furnish a copy of the affidavit filed by the said respondents on 8/9/2025 in the present proceedings on Mr. M. Sharma, learned counsel representing the
Respondent number 5.
Canara Bank, respondent number 5. Also, Mr. Sharma, basing on the content, shall complete his instructions as regards the contentions made in the said affidavit by the respondents number 1, 2, 3, and 4. Also, registry, to how long will it take to complete your instruction?
Maybe come up. 2 days may be given here.
Okay.
Because the office is here or else 25 may be given the words.
Okay. Registered to list this matter again on 25/3/2026. Any problem on 25?
Please, your lordship, we had filed an RTI, your lordship, to which we have received the reply, RTI reply. So your lordship may kindly dispose of the matter.
Dispose of the matter in what sense?
Because we have received the.
You have never prayed for an RTI direction for giving the RTI reply here. Where is your prayer for RTI reply? Nothing is there.
Your lordship, we had filed an RTI, but the.
Fine, I got it. But here you want a CBI investigation.
Yes, your lordship.
Huh?
Yes, your lordship.
So if you have got an RTI reply, you do whatever you want to do. How can this writ petition be maintainable? Where is the material for this court to draw conclusion that the respondent number 1 had misutilized the MREGA funds? Are you there in the case?
No, your lordship.
Who is there in the case?
My senior, Mr. T. Deori, your lordship.
T. Deori.
Yes, your lordship.
Call him.
Yes, your lordship.
Yes, who is appearing for the respondents?
Lordship, I am appearing.
Ah.
In this case, Lordship, AFDC is the person. He has not provided copy to the AFDC. It is AFDC, Lordship, not fishery. So we'll give the instruction. Lordship, here the bill is there. We have to go through it. Some scam is also there. I don't know whether this is that part or not. In some vigilance inquiry, many vigilance inquiry, MD is suspended, dismissed.
These copies were with your authorities?
For fishery, a copy for the AFDC also may be given. A copy may also be given. He has not provided copy to us, Lordship.
Who is the main authority to release this? FDC.
AFDC.
FDC has not received the notice.
Notice. No, AFDC has received the notice. But yes, but it is not on that day. In my absence.
On the prayer of Mr. P. Sharma, learned. Standing Council.
AFDC.
Fishery Development. Appearing for the respondents number 3, 4, and 5. Submits that he be granted 2 weeks' time to receive instructions with regard to the claim made by the petitioner herein for releasing his contractual dues. Prayer accepted. Raised BK Google. Registered to list this matter after 2 weeks on a date to be fixed.
Lordship, can it be 3 weeks, Lordship?
3 weeks. Before the next. Huh? Registered to list, 10/4/2020. By the next date of listing, Mr. Sharma, P. Sharma, learned Standing Council, respondent number, Standing Council, AF.
AFDC and fishery.
AFDC lady.
Appearing on behalf of fishery also.
All.
All.
1, 2. Appearing on behalf of the respondents number 1 to 5.
6, 7, my lord.
Mr. P.K. Medi, learned counsel is a government advocate, appears for respondent. Mr. P. Sharma, learned counsel appearing for the respondent number 1, right? Praise that he be granted, huh? In the Mr. Sharma shall ensure that by the next returnable date, before the next returnable date, the affidavit on behalf of the respondents represented by him is invariably brought on record. So, in the event the affidavit is not so, no, affidavit is.
Obliged.
Yes, Mr. Deori.
Your Lordship, the respondents have not filed their affidavit till date.
Sorry, you explain first.
Your Lordship, they have.
How can this prayer be entertained? What is the material to entertain this?
Yes, Your Lordship, but.
We'll have to do it in air.
No, Your Lordship, I understand, but they were not providing us with the.
That is a different
Yes,
issue
yes.
altogether. You have not prayed for that.
Yes, sir.
You have prayed for an investigation without a material. You'll have to withdraw this. Others will have to dismiss it with cost.
Then I will be allowed to withdraw.
Mr. T. Deori, learned counsel for the petition, after attempting to argue the matter at some length, submits on instruction that he be permitted to withdraw the present writ petition. To pursue with liberty to pursue the matter before the respondent authorities. Full stop. Prayer accepted. The present, in view of the submissions of Mr. T. Deori, learned counsel for the petition, the writ petition stands dismissed on withdrawal with liberty as per. You file and if you have that RTI now, file and.
Definitely. Obliged.
See, Lordship, I am waiting for instruction, Lordship. Otherwise, Lordship, this is, the amount is a lower side, Lordship. Lordship may dispose of in the line of Tomserali, Lordship. Lordship may dispose of in the line of Tomserali to examine directing the chief engineer to examine, Lordship.
We are not here to do that. Tell me whether you are admitting this or not.
Lordship, then I have to take instruction.
Why did you not take instruction? How we dispose, we will see. But you give me your instruction whether this is admitted or not.
I need some more time, Lordship.
How much time more?
2 weeks.
5 o'clock?
2 weeks, Lordship.
2 weeks, why? What were you doing from 6 to? All thing. Yes, come. Lakh rupees is spending. For you, it may be nothing, but for him, it may be much. We'll have it on 20th. On the prayer on Mr. N. Upadhyay, 11th Standing Council. Irrigation Department. Registry to list this matter again on 20. Any problem or 20 Eid is there?
Maybe it, my lord.
Okay. 25?
My lord.
25. 25. 25, huh? On the next date of listing, Mr. Upadhyay shall apprise this court as to whether the claim contractual dues claimed by the petitioner is admitted to by the respondents. You get it in writing for me. Yes, Mr. Chaudhary, what are you waiting for so pensively? Okay, we'll take it ahead. Mr. Ahmed is here.
I'm hearing, madam.
You are here.
Yes.
Okay, we'll take it up as the next time. Because we don't want to keep the DAY SGI tied up in court number 18. He'll be required somewhere else also.
I understand.
Yes, item number
6.
36.
My lord, in this case, my lord, an affidavit has been filed by the respondent, my lord.
Okay.
I need to file a reply because he lived in South Salma because of curfew and he could not come up. 2 weeks time may be given, my lord.
Okay, that land.
Yes, my lord.
In fact, my lord,
Land is in his name. But you
affidavit
say
is
that the land is
satisfactory.
used by PWD for a long time.
But that whatever been stated, nothing, my lord, in affidavit. So I'm also not with a satisfaction that it is a right
nothing is-
affidavit.
If the land is taken over,
Can I make a prayer for a fresh demarcation, my lord, along with the presence of the petitioner and other officials, so that we can get hold of the appropriate
see,
portion of land
if
which
the
is
land
used,
in the land records is in his name,
my lord.
you are utilizing it irregularly or illegally.
Yes,
Will he not be entitled to a
definitely, my lord. For that is why
For court's order, my lord, I am praying for a fresh demarcation with, along with the PWD officials.
My lord, they may do it, my lord. Till
We'll
then.
dispose it off.
My lord,
Basing on that, they will,
Because they are not denying that it is not his patta land. So
they have rather.
admitted fact, my lord.
If acquisition is made, my lord, then as per properly,
But
acquisition is made as per law, my lord.
if PWD is using that land without any acquisition, his entitlement is very much there, my lord. So this affidavit is not satisfactory in
No, no,
my humble submission, my lord.
Till demarcation, my lord, interim may continue, my lord.
So we'll dispose it off.
My lord.
We'll say direct the deputy commissioner.
My lord.
to
Along with
act,
the all concerned officials,
The demarcation in
presence
the
of-
presence of the PWD
as
officials
well as
and
the
the petition. Nobody else is required.
No, my lord. If PWD is appearing that they are the only requiring department, my lord.
How long will you take to complete it?
As it's a election session, my lord, little bit more time, my lord.
We'll give you 3 months time.
Yes, my lord. Till then, no
No, my lord. Till then.
activities can be done over the land.
Anybody for the PWD department? Any, see, this is a plot of land, which which the government now says is in the name of, the patta is in the name of the petitioner. But they also say that it has been found that you have been utilizing this land for a long time. That will not give you any right until and unless you acquire that land.
In that case, Lordship, can I obtain some instructions from from the PWD?
Okay. On the prayer of Mr. M. Bhuya, Learned Counsel, appearing Learned Standing Counsel, PWD, registry to list this matter again on 26/3/2026 to enable him to complete his instructions in there.
I'll provide the affidavit copy to him. my lord.
Okay.
What instruction?
Mr. Bhuya shall ensure that the instructions that he completes his instructions and apprises this court of the stand of the PWD authorities on the next date of listing. Also, this is a matter of 26. Registry to list this matter again on 26/3/2026. 26/3.
Interim may continue, madam.
Interim order passed earlier to continue until further orders.
Hello.
Lordship, can it be on the 30th if possible?
30th. 30th for further hearing.
Lordship.
Hello.
Much pleasure.
Extra nine. मला कुठली पोळी आहे ना?
Wait, this is a lordship. My lord, here we are agreed for non-payment of our dues, my lord, which we, according to us, my lord, is 29,43,000. And the respondent number 2, 4, 5, and 6 have
29?
My lord, it is 29,43,933 rupees.
933.
Yes, my lord. And respondent number 2 to 4 has filed an affidavit, my lord, in this.
They are the authorities who have to pay you that.
Yes, ma'am.
They have admitted?
They have admitted, my lord, an amount of rupees. 26,74,850.
26,74,000.
815 rupees, madam. But we have not received any amount, my lord, till
Yes,
date.
Mr. Chaudhary. Lordship, in both the cases together or in one case?
No, madam, I am representing 52. I am representing the
53 is?
53
Those are
and
similar
one more,
matters,
another.
Lordship. Now, this is under a scheme.
Forget it. No, he claimed 29, you are admitting 26.
I'm not admitting, this is a state. This is a state. Now, the fund is allocated by the center. It is utilized by the state. Now, if I may draw your lordship's attention to page 102 of the affidavit in opposition filed by my friend. Now, the scheme has long been closed.
Okay.
And the money.
Okay. That
was
there is
lying-
another matter also pending.
Both
Both are here today.
Yes, ma'am.
Okay.
53.
In the morning, my lord, I made a mention. My lord, I have received this letter, my lord. The inquiry is going on regarding the.
Oh, this is the matter you,
This is the matter, my lord.
that is why.
Now, this is the,
There is no admission. Scheme was yours,
scheme was ours,
executed by the state.
us, my lord, and the money was lying with the state till 2024.
Then what happened?
Lordship will come to page 102.
102.
102, it's a part of their
Affidavit,
affidavit.
ma'am.
Listen,
Yes, sir.
and more particularly to page 103,
Hmm.
paragraph 4. So they ought to have made the payments.
You asked for utilization certificates.
That is where we went wrong.
You should have asked for the recall of the amount. Okay.
This is the verification was ordered in item number 53 by the order dated 10/12/2020.
What happened thereafter?
The senior representing the state can appraise this.
He is already apprised. He made a mention in the morning, but consent was not taken from you.
I don't
That's
have
why we
phone number.
refused. Okay. Heard Mr. A. Ahmed, Learned for the petition. Also heard Mr. R.K.D. Chaudhary, Learned D.Y. SGI, appearing for the Union of India, response number 1. Also heard Mr. S.P. Das, Learned Standing Counsel, Labor and Employment.
So now it is about deferment. Now it is about skill, employment and entrepreneurship.
Skill, employment.
Skill, employment and entrepreneurship department.
And?
Entrepreneurship.
Entrepreneurship. Appearing for the response number 2, 3, 4, 5, and 6. And Mr. A. M. Bhuya, Learned Standing Counsel, Finance Department. Mr. S.P. Das submits that in terms of the direction passed by this court, wide order dated 10/12/2025, an inquiry is already underway in the matter, and accordingly prays that he be granted further 4 weeks' time to bring on record the inquiry report. Prayer is not objected to by the Learned Counsel for the other parties, but Learned Counsel for the petition. Also, in view of the above, raised it to list the above noted report after 4 weeks.
4 weeks
date
will
to
be
be
long, Malak.
explained. Huh?
Sir, 3 weeks if possible, Malak. 4 weeks.
Oh, they are doing an inquiry, big inquiry.
Hello.
Take time, there is election.
Yes, madam. That's the problem.
Date may be fixed, Malak. If possible, date may be fixed, Malak, after 4 weeks.
Oh, 4 weeks, why you come and mention, I'm here. And this time I don't get the report. Mr. Das.
It's under process, madam.
But this
they have
inquiry
to-
should be made by you, Mr.
They have to pay us 10 crores, my lord. They are denying it. 10 crores, my lord.
Who?
Government of India.
You gave or Government of India?
Government of India has to give us, my lord. It's their scheme, my lord. They told us to implement it. We were only the implementing agent, my lord. Now they are saying that, no, you pay it. There's the dispute between us, my lord, now, my lord. 102
That will go before the Supreme Court.
Yes, my lord.
102 is very clear. The money was with them.
Utilization certificates.
Utilization, that is what.
Have you submitted the utilization certificates?
That is the going on. That inquiry is going on.
Why? A scheme of 2020?
2011, my lord, the scheme.
No, it was closed in 2017.
17.
And
8
they
years
informed us
down
of
the line.
2024.
Money was there till 2024.
No. That is the dispute.
Then what happened to the money?
My money.
Where are the utilization certificates of the money?
That I'll check, my lord. That I'll bring the instruction. But the scheme was closed on 2016 by an email, and they have informed us that the scheme had been closed on 2024, my lord. I mean, we have filed the affidavit also. It's on record, my lord.
Okay.
Not problem.
Okay.
Please, I have received instruction, lordship. So far, the instruction, lordship, authority has already released part payment, lordship. Out of admitted amount, lordship, 9 lakh recently has been.
Have you received?
Lordship, 9 lakhs.
May I?
What is the admitted amount?
Lordship, the
Now-
total amount due was 82 lakhs 53.
Out of that, 9 paid.
Nine.
When are you paying the balance?
Balance is under process, Lordship.
Under process.
Under process.
When? By 31st? Before 31st?
When PAN will come, Lordship?
Fine. Why did you
PAN
get the work
position is
executed?
maybe
Yes, Mr. Mukherjee, what is the work
Lordship,
involved?
Lordship, it was construction of a road, your lordship.
Why did you get it, executed through him if you don't have money? Is he bound, duty bound to execute works without money?
Lordship in the line.
He is doing
temporary-
it graciously.
Lord-
Huh? And why, when are you going to pay?
Next financial.
You
year,
have
Lordship.
extracted work from him,
Yes.
right? Why did you, if you don't have funds, why did you earmark that work?
Lordship. Next financial year, Lordship.
Next financial year is May 2027, March 2027 it will end. So it gets,
That is why, Lordship.
you open up a year.
PAN is not,
Money,
cannot be
money
available.
can't wait. A person is in trouble. Money can't wait. How long will it
Not
take?
only the
1 month,
present
2
petitioner,
months?
Lordship. So
9 lakhs. Paltry, nothing. Not satisfactory. When are you paying the whole amount? You have admitted the dues.
now remaining admitted amount.
Mr. You have admitted
Yes,
82
Lordship.
lakhs something.
As per this instruction, I admitted.
Admitted. Mr. BC Mushahari, learned, Standing Council, BTC. Submits that. He has received instructions in the matter. But there is an order here. How can we go beyond this? That if you don't file it by today, we are going to dispose it of basing on the materials. Give me your instruction. So we are disposing it of, pay him within 3 months, if not interest at the rate
No,
of
no interest, Lordship.
6% per annum.
No, Lordship. I haven't.
I am directing. Who is asking your
No,
consent?
then I may be allowed to bring on record.
What? 50,000 rupees cost.
No, Lord. Kindly, Lordship.
50,000 cost, because here it is expected that, and the lot, and this court had passed a detailed order. Quoting
Now, Lordship,
Supreme Court decision, it is expected that the BTC
I
authority.
spoke for instruction, Lordship. Instruction has been, I have received.
You hear this order, you so seek whatever you want to seek. We'll go by our orders. It is expected that the BTC authorities will conduct itself in a responsible manner and assist the court by placing the true and relevant facts by filing appropriate affidavit and
Our
documents
authority has
that
so
may
many.
be available to it within 13/3/2026. In the event no affidavit is filed by the authorities on or before 13/3/2026, the writ petition will be taken up for consideration on the basis of materials on record and by following the doctrine of non-traverse. Now what can I do? You have not gone up on appeal. This order has attained final. Where is your senior standing counsel, Ms. Bhuya? She had taken time.
Lordship. Then tomorrow, Lordship.
No, today. If it crosses, it is.
Today, my senior is not available.
Then you argue.
So for this instruction, I may be
That
allowed to bring
instruction
on
you
record.
keep it. We wanted an affidavit.
I may be allowed to bring on record, Lordship.
So you bring, who prevented you? This order was passed on 6/3/2026. The communication is of 9/2/2026. You did not have time to file an affidavit.
I always take instruction, Lordship.
You
And
don't
so-
file affidavit.
No, Lordship. Today
In spite of court's order, you're not going to file affidavit.
I will file, Lordship. I will file.
But you had to file today.
Today, Lordship, I'm sorry, Lordship.
Then you be sorry. We are
Tomorrow, Lordship. Tomorrow, I may be allowed to file tomorrow. This is all pending bill regarding
We are not concerned with the bills. We are not concerned with the.
We have
Mr.
huge
P.M.
liabilities,
We are concerned with our order.
contractual bill, Lordship.
We are concerned
only
with
this
our order.
writ
We
petition,
are
Lordship.
concerned with our order.
And next item also, same matter, Lordship.
Next
contractual
item will
bill.
be seen when it comes up.
Lordship.
How much?
Tomorrow, I may be allowed to file, Lordship. This,
Subject to payment of 5,000. Yes.
Lordship. I have received instruction, Lordship. Kindly may be allowed to file tomorrow, Lordship. I will file definitely, Lordship. In 6 months, Lordship. Maybe dispose of in the line of always.
No, I'll accept your first thing. I'm giving you time till day after tomorrow, subject to payment of 5,000. Why do you violate our orders? 6/3/26 categorical statement. Ask, confer with your senior and come back.
Lordship, yes.
We'll take it up
Lordship.
at 3:45.
Lordship. Reporting. All of different.
How much is here?
22 lakhs, 22,206.
Yes, what is your admission here?
Lordship, kindly. For a
This
moment.
is the second time read petition.
Huh?
This is the second time read petition. Earlier there is an order, my lord, on page 18.
Yes, Mr. What is your instruction here?
May I, Lordship? I have
Yes, please.
এটা আছে, port আছে।
Why?
Fund is not available. Lordship.
Fund is not available, then why did
In the
you
line of
let the work-
Tamsirali, Lordship.
Huh?
In the line of Tamsirali, maybe disposed
No.
of.
Earlier order was Tamsir
There is no Tamsher Ali.
And
Tell me when you are releasing the.
so far, my instruction.
Mr. B.C. Musahari submits that the contractual dues amounting to rupees 22. Where is your amount that you claim here, Miss?
Phase 2.
Huh?
Phase 2.
Page 2. Oh, they are giving you more than that. Contractual dues has been admitted by the respondent, by the PTC authorities to the extent of rupees 22,24,238. I read it, rupees 22 lakhs. So, in view of the above, the dues of the petitioner being admitted to the said extent, Mr. Mushahari on the next date of listing shall apprise this court as to the period during which the said amount shall be released to the petitioner. Also, Mr. Mushahari projects that on account of absence of fund, under the SOPD account, the amount due to the petitioner was not possible to be released. Also, PTC authorities on the next date of listing would apprise this court as to the amount they are in a position to immediately release to the petitioner.
No. And my lordship, I may be allowed to file our affidavit. I will bring it on.
Mr. P.C. Musahari prays that he be permitted to file his affidavit. Also, this court had not restrained the respondent authorities from filing their affidavit. Also, any pleading of the party, the respondents are at liberty to bring on record their pleading by the next date of listing. That registry to list this matter again on 3/03/2026. No further time shall be granted for filing of affidavits by the respondent BTC, by the BTC authorities. Full stop. 33. You take that instruction, come back and tell me.
In this.
In this case, I have to file my affidavit, Lordship. Lordship may give it 2 weeks' time, Lordship.
What is your instruction?
Instruction I have received Lordship, today, Lordship.
What?
And they have admitted, Lordship, an amount of rupees 16,77,000, Lordship, out of, Lordship.
That much you will get.
Lordship.
Not more than that. I can't direct for payment of an impound, of which they are not admitting. Ms. Nanda, if you agree, we will.
Let them file the affidavit.
Mr. N. Upadhyay to file his, submits that he has received the instruction in the matter. And as per the said instruction, the respondent authorities have admitted the contractual dues of the petitioner to the extent of rupees 16,
77,
77,
100.
100.
00. Lordship.
Mr. N. Upadhyay shall bring the said stand on the part of the respondent authorities on record by way of filing an affidavit on or before 30/3/2026. Registry to list this matter again on 6/4/2026.
Obliged, Lordship.
Obliged, Lordship.
May I plead your Lordship, order has been complied with.
Mr.
M. Dekal.
M. Deka, Learned Counsel for the petitioner. Submits that the respondent authorities have complied with the directions passed. Had Mr. So-and-so, Madam, your name?
PCA.
PCM, Learned Counsel appearing for the respondents. All the respondents?
Yes.
For the respondents. The present contempt petition has been instituted alleging violation of the directions passed by this court-wide order dated 11/7/2016 in WPC number 3956/2016. The Learned Counsel for the petitioner on instructions has submitted that the directions passed by the said order dated 11/7/2016 have been complied with by the respondent authorities. Also, the said position is a FUSA. In view of the above submissions made by the Learned Counsel, in view of the above submission of the Learned Counsel for the petition, there being no allegation of violation of directions passed by this court by the order date, said order dated 11/7/2016, the present contempt petition is not detained any further for adjudication, for consideration. Accordingly, the present contempt petition stands closed.
Matter, my lord, petitioner has to take steps on respondent number 5, 6, and 7. That is.
Nobody is appearing.
And one of my noting in file, my lord, on 37/2025 may be reflected in the order that petitioner also not survived, ma'am.
Survived.
So institution of substitution petition might have.
37.
Yes, my lord. I have not checked the court file, my lord, but there is a noting. Petitioner to place substitution petition.
No, it's not recorded. None appears for the petitioner on call.
So far as prayer is concerned, my lord, in this writ petition, they have to ought criminal cases against the respondents, my lord. That is not done. No steps, no mention in the pleadings that they have initiated any steps Because in read
Uh,
court, that cannot be a direction, my lord, in my humble submission.
Huh?
That in a read court, my lord, without taking that steps,
Cannot be.
cannot be
Last time also there was no representation on behalf
on behalf of the petitioner. My lord.
Today, so we are dismissing it.
May lost interest also.
None appears for the petitioner on call. Ms. M. Burman, a learned government advocate, appears for the state, for the respondent number 1, 2, and 4. Also, the petitioner is also found to have not taken steps for service of notice upon the respondents number 5, 6, and 7. Also, on the last date of listing also, on the last date of listing, that is on 18/12/2025, found that there was no representative on behalf of the petitioner. Also, in view of the above position, this court is of the opinion that the petitioner has lost interest to pursue with the present writ petition, and accordingly, the present writ petition stands dismissed for non-pro.
Obliged.
The petitioner was permitted to effect service of notice upon the sole respondent by way of dusty mode. Also, however, it is seen that the petitioner has not taken steps in this connection in pursuance to the said order dated 18/12. For the ends of justice, registered to list this matter again after 4 weeks. The petitioner to take steps for service of notice upon the sole respondent in terms of the directions, in terms of the liberty granted by this court-wide order dated 18/12/2025. None appears for the petition on call. It is found that the petitioner, there was no representation on behalf. No representation on behalf of the petitioner. The speaker Medi appears for the
M City, madam.
M City, Learned Council, the government advocate appears for the state respondents. Also, for the ends of justice, registry to list this matter again after 4 weeks on a date to be fixed. Yes, madam.
Not here, the petitioners are the widow and 2 minor daughters and aged parents. They have lost their son, father and husband here, praying for.
Oh,
Yes, my lord.
Labor.
Yes.
Bridge,
Yes,
that railway gate.
Yes. I have taken steps upon those newly implemented parties also, however, they have not appeared.
What happened to that step?
Him to be served, my lord, and then him to be served.
Served.
Yeah, my lord.
We have filed affidavit on behalf of Chief Electrical Inspector Mali. Report is before your lordship. that is by respondent number 7.
Registry to list as the service of notice upon the respondents are complete, comma, this court had wide order dated 2/2/2026 have directed to list this matter under the admission column. The matter is found to have been again listed under the orders column. Registry to list this matter after 2 weeks in the admission column also. The parties may, in the meantime, complete their pleadings if so advised.
Obliged.
Yes, Mr. Burwa.
Well, that steps has been, fresh steps has been taken to respond 6, but I think the Redicat not returned. Town committee goes again.
Registry to await completion of service of notice upon the respondent number 6 for further 2 more weeks.
Plus.
Yes, Mr. Doctor.
The state has filed a review. I filed a reply today in the morning, Milord.
Reviewed लिखी बात है, just reviewed लिखी। कहाँ से ना? Mr. M. Doctor, learning counsel for the sole respondent submits that affidavit on behalf of the said respondent has been filed today. You have received a copy?
Yes, my lord.
So, this, however, this registry to trace and tag the said affidavit along with the records of this case on the next date of listing. Registry to list this matter again when?
Any date, my lord.
Eight. And I like beauty should get. This tarikh. 21 point.
21st.
21st. 21/4.
Obliged.
Along with contempt petition 37/2020. Huh? Contempt of petition listed.
Lift up, Your Lordship.
Please, Your Lordship. Lordship, in this matter, we have filed an IA for impeachment, Lordship.
Yes, any objection?
Lordship, I don't believe we have received the copy of the IA which has been filed.
No. H. Burwa.
H. Burwa.
H. Burwa, learned counsel accepts notice on behalf of the opposite party who is sought to be impleaded. H. Burwa is your.
Yes, Lordship.
You have got 10 lakhs on.
Yes, Lordship.
Education office.
Now, why do you want to implead the Director of Health Services? He has approved.
Yes, Lordship. In the remaining amount of rupees 5,17,000.
What is the approval granted by the Director of Health Services? Amount.
They had admitted the amount of rupees, Lordship, 10,58,000.
By the Director?
Yes, Lordship.
Where do I get it?
Lordship, we have, Lordship,
11,925.
Page
Page 3.
of the,
Page 3 of our alia, Lordship.
no. Page 3 of the I. Now, who is this respond authority? The director.
Yes, Lordship.
We'll allow it. Or you have some objection?
Lordship, we have no objection, but I believe the main parent department would be the education department.
Okay, fine. Now, where is the certificate of the director of director of health service
Yes,
in
sir.
your writ petition?
Medical expenditures and bills. Where's the 37?
So this certification about your dues, the receivable will have to be made by the director of health services. Where is that made? Admissibility report, director of health service. You don't have that. I agree. We'll implement it.
Lordship,
The, not Mr. M. Sharma, no. R. Gohan, learned. Council for the petition of Mr. M. Bhaiya, learned. Standing council, health department. You're there?
Lordship, but the name of the health has not been reflected, but it can be there.
Or will not, Mr. D.
Upamanu is there.
Learned. Standing council, health and family welfare department. The applicant hearing had instituted the connected writ petition being WPC number 5210/2025. Inter alia praying for a direction upon the respondent authorities to release an amount of rupees 15,75,969,95 towards his medical reimbursement bill. So, the respondent authorities, however, basing on an admissibility report given by the Director of Health Services, Assam, had held that the petitioner would be entitled fully to an amount of rupees 10,58,910. The Learned Council for the petition submits that, for the applicant submits that inadvertently, the Director of Health Services, Assam, was not impleaded as a party respondent in the proceedings of WPC number 5210/2025 due to inadvertence. He submits that the entitlement of the petitioner now being for being reimbursed his medical bills being now based on the admissibility report submitted by the Director of Health Services. The Director of Health Services, Assam, is a necessary party in the connected writ petition, and accordingly, the present interlocutory application has been filed for impleading the said authority as a party respondent in the connected writ petition. Mr. D. Upamanu, Learned Counsel for the petitioner, submits that the admissibility report having already been contended to have been submitted by the Director of Health Services, the Director of Health Services Assam is no longer a necessary party in the present in the connected writ petition, and the matter is now required to be processed by the administrative department, that is the education department. I've heard the Learned Counsel for the parties and also perused the material. The petitioner having claimed an amount of rupees so and so and his eligibility having been determined at rupees 10 as the bill reimbursement bill. And the eligibility of the petition being determined at an amount of rupees 10,58,9. So basing on the admissibility report submitted in the matter by the Director of Health Services, Assam, this court is of the considered view that the Director of Health Services is a necessary and proper party in the connected writ petition. Also, in view of the above conclusion reached by this court, the present interlocutory application stands allowed, permitting the petitioner to implead the Director of Health Services, Assam, Hengrabari, Gauhati, -781036 as party respondent number 4 in WPC number 521023. The above observations and directions, the present interlocutory application stand. Next, WPC. In view of the order passed today in I(C) number 3883 of 2025, permitting the petitioner impleading the AMIDB, Director of Health Services total, as party respondent number 4 in the present semicolon. Petitioner to file an amended cost title within 2 working days from today. Mr. D. Upamanyu, Standing Counsel, Health and Family Welfare Department, accepts notice on behalf of the newly impleaded respondent number 4. No formal notice is. However, requisite extra copy. Also, registry to list this matter again after 3 weeks on a date to be fixed by reflecting the name of the Standing Counsel, Health and Family Welfare Department list.
Highly utilized.
Lordship, we have sent the affidavit for vetting, Your Lordship. It will be coming by tomorrow.
But the order is today. How can I do this?
Lordship, there's a communication, and just now I have telephonically talked to the legal officer. It is in active consideration within this financial year. It will be disbursed. So may I pray before 31st, this matter may be fixed, my lord.
But madam, there is a direction here.
Yes, my lord.
That you undertaking given that you mix a miscommunication, the instruction could not be filed today. Accommodation to obtain instruction, that was your prayer. Then the Supreme Court decision is quoted, and this court said that in the event no affidavit is filed by BTC authorities on or before so and so, writ petition will be taken up for consideration on the basis of the materials on record by following the doctrine of non-traverse.
Lordship, then Your Lordship, in the by following the decision of Tamsher Ali, Lordship, maybe please to dispose of.
First, we'll have to penalize you. Then only we can do. There is a clear-cut order.
There's some communication gap. Maybe it is by court number 6, maybe. Court number 6, my lord.
It's my order now. No, not mine. Any order passed by this court would be the order of the judge.
Yes, no, I mean to say, I personally appeared on that day. So matter speaks on some.
Miss Bhuya, learned senior counsel and senior counsel BTC and standing counsel BTC submits that the affidavit in the matter would be brought on record by tomorrow. By tomorrow, 17/3/2020. She further submits that the contractual dues of the petitioner, which has been admitted contractual dues of the petitioner amounting to rupees 8253,583, right? 8252,583.
It's okay. Plus person. Lordship, actually 4 lakhs and 5 lakhs has already been, and 73 lakhs, 53,583. I am very poor in mathematics. Plus per
73.
calculator, fine?
Yes, 76.
Not paid. 73, 53, it is due.
It is,
Yes?
it is due.
An amount of rupees 82,53,583 has been admitted to by the authority, by the BPC authorities. She submits that an amount of rupees 9 lakhs has already been released to the petitioner on. When was it released?
Lordship. 5 lakhs financial sanction on 24/12/2020. 4 lakhs financial sanction on 24/12/2025 and 5 lakhs on 8/1/2026.
When you have received that 9 lakhs?
Received?
Yes, yes.
9 lakhs has already been received, and the remaining amount of rupees
73, 53, 583.
583 would be released within the current financial year. So, in view of the above submissions of the learned counsel for the respondent BTC, this court directs that directs the registry to list this matter again on 30/3/2026.
But I have received telephonic instruction, my lord.
That we don't know.
Yes, my lord.
If your authority has given you
Lordship.
an impression,
My lord.
can't help it.
By tomorrow we'll file it.
You have to.
Deeply obliged.
Madam, ask your team to be a bit careful with.
Lordship.
Because if we pass an order that is not complied with,
My lord.
then we can't go even
My lord.
against our orders.
Lordship.
It is your lordship. This is a review petition, your lordship. Praying
Where is the order?
order is at the first part, your lordship. 21/1/2025.
Madam, the order you want to review.
That has been annexed in the first part of the review petition.
Yes, what is this?
What happened in this case, your lordship? That withdrawal has been done without proper authority or instruction. When this the
You do one thing, you file a complaint against him before the BCA.
well, that has been done under bona fide misconception of fact
What bona fide misconception?
that disputes between two central government entity is not maintainable due to national litigation policies of 2010 and 2015. Along with that, and one judgment also has been cited, that is 2011 3SSC 434. Now, 2 letters has been sent by the learned counsel to the review petitioner for consideration and further instruction. But the review petitioner, what is the grievance raised by
No, what is the error done by this court?
error? There is
And
nothing.
how can a review be maintainable if there is no error?
In certain cases, your lordship,
We don't have any power. And beyond the powers of review given in the CPC.
in that case, your lordship, I may be allowed to withdraw with the liberty to file appropriate applications, your lordship.
What appropriate application?
Recalling and restoration of the writ petition.
That will also not do.
There are provisions. Because the review petitioner will be because
Because this is a withdrawal on the prayer of the petitioner on instructions.
but there is no authorization has been taken from the review petitioner, your lordship. These applications were pending before the authority, and no without taking instruction that that has been stated in our as grounds, your lordship.
But madam, if we have to dismiss this petition subsequently, it will
Because-
be done with heavy cost.
Lordship, in these cases,
Just for your consumption, that if we have to dismiss this subsequently, on discount, and we find after the respondents have come up before us, then it will be very heavy cost imposed on your,
regarding the review petition, your lordship. In that case, I may be allowed to withdraw and file a fresh
No.
for recalling and
No,
restoration.
no, recall will not do. We will move with this. But if we
Restoration.
have to dismiss this, madam, it will be very severe. Just be careful with that. Hut Miss S. Dasgupta, Learned Counsel. And where is this counsel, Mr. Dilip De?
He has been depaneled because for this case actually.
He
without-
has filed this.
Yes, in the year 2025, he has filed this. Later on, I have been given the duty to.
But how he is, okay, let us see his statements. This case was not filed by you.
No, Your Lordship. In the year 2000, because basic 2014, the writ petition was filed. Challenge.
Where is your grounds on that?
Yes, Your Lordship.
Review.
Page number 11, Your Lordship. Grounds are there in for the round number 1, 2. So statutory liabilities were there to be paid by the respondents, Your Lordship. And we have came before this honorable court, challenging the order of the tribunal that gone against us, Your Lord. Against the department, Your Lordship.
Miss S. Dasgupta, Learned Counsel for the petitioner. Review petition. The present review petition has been instituted. Praying for review of an order dated 21/25 passed by this court in WPC number 6225. This court, by the said order dated 21/2020, had dismissed the writ petition on withdrawal basing on the prayer made by the Learned Counsel for the present review petition. Learned Counsel for the writ petition. That is the present review petition. Also, Ms. Dasgupta submits that the said withdrawal was based on a misconception and there was no authority granted by the review petitioner for making the said to the Learned Counsel for making the said prayer. In view of the above, issue notice returnable 4 weeks. Ms. The petitioner to take steps for service of notice upon the sole respondent by way of speed post. Steps within 2 working days. Registry to list this matter again after 4 weeks on a day.
Forty-seven is also same, Your Lordship. Same common order, Your Lordship.
2 writ petitions disposed. Where is the impugned order here? View.
That actually was not annexed most probably at the time. This is the first part of the review petition. Later on, it has been annexed as annexures, what I found in the record. Your
Same order.
Yes, Your Lord. Common order. 6225. It has got.
Go to date 2 again. So tomorrow read 6/225/20. Therein the writ petition number was?
That was 466.
Like no,
4641 of 14.
4621 of ঠিক আছে, এইটো 62225/40
Much obliged.
May please, Your Lordship. Lordship, in this matter, on the last occasion, Your Lordship has asked us whether any case was pending. Whether any case was pending before the Education Tribunal in this matter, Your Lordship. So no cases are pending, Lordship. In fact, the two cases which the respondent has mentioned, one was withdrawn and and in another matter, the petitioner was not allowed to be a party. And both the cases, those cases were not filed by the respondent number 7. It was filed by Saira Khatun.
Your name?
Manwara Begum.
The private respondent is?
Ashraf Ali.
Registry to list this matter after a week. Oh, so registry to not, the present matter we not treated as a tied up and a parted matter before this court any further. Bench 2 is not there, so I should not be taking.
Any date may be given then, Lord. Any date?
As prayed for by the Learner Council for the parties, registry to list this matter again on 31/3/2026. 33/2026.
Obliged, Lordship.
49.
May to you. The I is for continuation of delay, my lord. For my lord,
review to some.
Lordship's order is at my lord page 6, page 28. Oh, sorry, my lord. 16, no?
Yes, what is your grievance here with this order?
So, my lord, our petition was, my lord, dismissed on the holding that we are not, my lord, eligible under Rule 12(3), my lord. In view of, my lord, the secondary education of the Provincial Service Rule 2018, my lord. Subsequently, my lord, we have, my lord, preferred a petition challenging that order, my lord, that rule, my lord, Rule 12, my lord. But meanwhile, we came to know that that rule has been, my lord, amended.
With effect from?
With effect 2021, my lord. 2021, my lord, that is when we have annexed page 71 of my review application, my lord. 28/10/2021, my lord. Page 71, my lord, annexure 8.
Rule 12.
12, my lord.
So Soma, where is the amendment here?
My amendment, my lord, is page 71. Lordship. Page 70 of the.
1-7.
1-7-1, my lord.
7.
My lord. In review application.
Page 1?
7-1, my lord. Annexure 8.
71.
Yes, ma'am, 71.
Yes.
Amendment of Rule 12, my lord. In the principal rules in Rule 12, in Sub-Rule 3 for clause 4, the following shall be substituted, namely, the candidates must have rendered at least 17 years of teaching experience as graduate teacher in any high school. But that was not there, man.
Yes. Who is appearing for the state respondents?
Notice was not issued in respect of the condonation, man.
If that is there, we can allow this
Yes,
review
yes.
now only.
Yes, yes.
What better ground can you have for
Yes.
review?
I know.
But Mr. M.K. Sharma,
Man.
I'm a counsel for the petition. The present review petition has been instituted. Praying for a review of the order dated 3/1/2025 passed by this court in WPC number 7045/2024. The learned counsel for the review petitioner submits that the provisions of Rule 12 of the Assam Secondary Education Provincialized Schools over rules, 2016 as originally enacted mandated that a graduate teacher for being eligible for recruitment to the post of principal of a higher secondary school must have acquired 17 years of teaching experience as graduate teacher in any higher secondary school. The petitioner, admittedly not having 17 years of teaching experience, having garnered 17 years of teaching experience in a higher secondary school, this court, by the order dated 3/1/2025, had proceeded to dismiss the said petition. Also holding the petitioner to be not eligible to apply for the post of principal involved in the said petition. Mr. Sharma has, by referring to an amendment of the carried out in the rules of said rules of 2018, in the year 2021, has submitted that after the said amendment, the provision of sub-rule 3, bracket rule 4, Roman 4, it is now mandated that a candidate for a post of principal must have rendered at least 17 years of teaching as graduate teacher in any high school, high madrasa school, higher secondary school, higher secondary and multi-purpose school, or in combination of such schools. Mr. Sharma submits that the petitioner before his transfer to, what is that school here?
Bokazan
Bokazan
Higher Secondary School.
High Secondary School. With effect from 24/8/2012, comma, the petitioner was working as a graduate teacher. No, where is the post of principal that has come?
My lord, that is at Bokajan HS school, my lord.
Same school.
Same school.
Same
I
school.
was, prior to joining that school, but I was at HDB High School, my lord.
Where is that? Where do I get it?
Page my lord 7, my lord, of my review application, 5.3, that I have clarified where I have gathered the experience, my lord.
5.3,
my lord.
Was working as a graduate teacher in HIDIPI, HIDIPI, high school. So accordingly, he submits that the petitioner has acquired the requisite qualification for applying against principal. Mr. Sharma submits that the said amendment affected in the provisions of the rules of 2018, comma, in the year 2021, comma, was not placed before this court, and in the event the said amendment was placed, the conclusions drawn by this court would have admittedly been different. It is in the above background that the present instituted by the petition. Issue notice returnable by 4 weeks. Yes. Huh? Council accepts notice on behalf of respondent number 2, 3, and 4. Ms. Taranpi Kwedivida, H. Taranpi, Learned, Standing Council, Department of School Education accepts notice on behalf of respondent number 1. So, as all the respondents are represented, no formal notice. However, requisite extra copies of the review petition, so and so on. Registry to list this matter again after 4 weeks. So, IS Civil 7/28/2026. Mr. So and so from, huh? The present interlocutory application has been instituted, praying for condonation of delay of 376 days in filing the accompanying review application. No objections, I suppose. The Learned Council, the review application was mandated to be so instituted, basing on a fact which had come to the knowledge of the petitioner much after the passing of the order dated, much after the disposal of the connected writ petition being WPC number 7045/2024, that the provisions of Rule 12 bracketed 3 bracketed 4 had undergone amendment in the year 2021, and in the event they said amendment, in the event the amended provisions of the said rule is so noticed, the petitioner had made out a prima facie case for issuance of directions in his favor in the writ petition. Also, the Learned Council for the respondents have not seriously disputed the condonation of delay. Seriously objected to the condonation of delay occasioning in instituting the connected review. In view of the above, the present interlocutory application stands allowed. Order to a registry to register the connected review petition and list the same before this court on Friday. 20. delivered the order, you'll get it on Friday.
My lord.
But just remind me,
My lord.
if the matter is taken up and listed on Friday,
My lord.
just make a mention so I can ask them to pass the order. You need not wait.
All right, your lordship.
How is Mr. Roy?
Lordship, he is okay because BP is only high, and after that he also went to do the ECG. It's normal, but he was not quite well, so he left.
Prayer is made on behalf of Mr. J. Roy, learned counsel for the senior counsel appearing for the petition for an adjournment in the matter on the ground that he is in this. Prayer is not objected to by the learned counsel for the respondents. Raised to list this matter again after 3 weeks on a date.
Highly obliged, Lord.
Here in this case, my lord, now, my lord, the petitioner is stuck, my lord, at the service of the commission service on the respondent number 5, my lord. Then, my lord, your lordship comes to order dated 4/12/2025, my lord. My lord, about this proceeding, my lord, the respondent number 5 was make ever, my lord. And he had also assured through the engaged counsel, my lord, sorry, departmental counsel, that he will contest the case, my lord. Now, my lord, he is not approaching the court, my lord. Neither he has engaged any other counsel. 4/12/28/1.
4 date.
4/12/2025, my lord. Order dated.
4/12/25,
my lord. There, 28/1, my lord, thereafter, my lord.
Yes, have you effected service after this?
Lordship,
As per their instruction, my lord, it was communicated, my lord. He had also assured through the jurisdictional executive engineer that he will contest the case, my lord. Subsequent orders, my lord, they are fine, my lord. (28/1, 2026), my lord. 9/2/2026 also, my lord.
Where is the acknowledgement? Where is the acknowledgement in terms of the 9/2/2026 order? Please go through this.
Lordship.
This man is from which place?
Corporate.
Your Pasa. Other petition earlier.
Yes. Jayapasa and both are contractors, my lord. They are having so many.
What is the other name? The person?
My lord, Minal Jutin, not my lord.
Did I appear for any of them?
I am, no, I am usually appear for Jayapasa, my lord.
Please.
Yes.
To court.
Name looks very familiar.
Lordship, this acknowledgement slip, I'm not aware of, but we have communicated to the.
No, but say, there has to be something on
Lordship,
record.
Lordship.
Get the acknowledgements.
Lordship.
Ms. M. Bhuya, Mr. M. Bhuya, learned counsel appearing for the
PWD.
Respondent number 1 to 4 submits that he be granted a week's time to place on record the copy of acknowledgement. Copy of the to place on record the acknowledgement copy of the notice given to the respondent number 5 about the pendency of the present proceedings. Also, as projected by the learned counsel, standing counsel, PWD, and recorded in the earlier orders of this, earlier orders by this court. In its earlier orders by this court, a copy of the writ petition was already served upon the respondent number 5. So, this court, while order dated 19/9/2026, had required the Standing Council PWD to place on record the acknowledgement received from acknowledgement of service of notice from the respondent number 5. Also, our piece of tolode uporo summons there. In view of the above, raised it to list this matter again on 1/4/2026.
May it please your lordship. Lordship, as per the office note, I believe the steps taken on respondent number 6 were not served, and the AD card is also not returned as per office note dated 2/2. In the meantime,
A letter has been received from the respondent number 6. Acceptance are also placed on part 2 file.
yes, your lordship. Lordship, another fact may be mentioned that the standing counsel for SBI for the all 3 branches have already been appearing. So they may also be directed to take instructions whether they can appear for the newly added respondent number 7.
No, where is the service of the upon the newly responded? Oh, notice has been taken. Till 2 steps have been taken.
Yes, your lordship.
Steps were taken on which respondents? Respondent number 6.
Yes, sir. Respondent number 7.
7.
Yes, sir.
But where is that notice about the respondent number? Notings about the respondent number 7.
It was, we were advised by the standing council of the SBI that we should add the respondent number 7 as generally they are in charge of direction.
Have you filed an application?
Yes, your lordship. We had filed an application IA number 215 of 2026. That should also be in there.
215.
Yes, your lordship.
Okay, here the order is now required. Who is the authority you want to now bring on record as a party respondent?
The Assistant General Manager, Surveillance and Investigation Department, State
It
Bank.
can be accepted by the
Yes, your lordship.
SBI only. SBI only.
SBI, that is our contention.
Where is the Standing Council SBI? Who is the Standing Council?
Aware of the June. If lordship's direct, then I can communicate. I'm aware of the.
Order sheet not having, the office note to not having me. Heard, Mr.
A. Mishra, your lordship.
A. Mr. Learned Counsel for the petitioner. None appears for the opposite party number 1, 2, 3. Also, for the ends of justice, raised it to list this matter again on. Let's take a party. 27/3/2026. Please inform them so that we'll have the notices up to them.
And in the meantime, your lordship, direction may be given for them to take instructions.
Not without bringing them in, why should I? Raised it to. You have not taken steps in this IA in terms of the order in 4/2/26.
You have, your lordship.
You have. It's not reflected. That's the problem.
We'll, if required, we'll take fresh steps.
No. Have you taken steps?
Yes, we'll.
Mr. None appears for the, it will be the opposite party. Mr. A. Mishra, learned counsel for the petition of some for the applicant submits that the steps for service of notice upon the respondent number 7 was already taken along with steps for service of notice upon the respondent number 6, 4 and 6. 4 and 6 also you have taken steps. The registry to put up a note with regard to the submissions made by the learned trial, with regard to the status of service of notice upon the respondent number 7, opposite party number 4, 6, and 7. Registry to list this matter again on 27.
Could it be earlier? Lordship?
25.
I'm deeply obliged.
Because thank you.